May I please, Lordship? Lordship, with the consent of the other parties, Lordship, I beg to mention item number 6 for adjournment, Lordship.
No, we've already fixed it. No adjournment.
Lordship, my senior is...
I'm sorry, you are here. You are here. You cannot adjourn all the time. This was fixed. This is a fixed, it was fixed on 19/1/2026. I mean, not that. It was fixed. And the date was specifically given. Sorry.
Lordship, Lordship, he is unwell, Lordship, that's why, Lordship. Lordship, and in the meantime, Lordship, there is also some documents need to be filed.
No
Lordship.
need. This is a PI, no. Sorry.
Oh, please, Lordship.
What is your name?
Lordship, B. Chakma, Lordship.
B. Chakma. You are here.
Lordship, yes.
For mission, item number 1.
Lordship, I have filed my affidavit yesterday.
Where is it? Oh, okay, this one. Yes, madam, what is to be done now?
Lordship, as per the affidavit filed yesterday with the main PIL affidavit, on page 4 they have listed some of the works executed under 5054, and on page they have mentioned 3054. This work has been finished. These are internal roads, Lordship. The main stretches of road which we have highlighted in the additional affidavit are the main 4 roads.
Which roads?
Main 4 roads, Lordship.
Which are the 4 roads?
Yes, Lordship. Aizol to Kolasip to Silchar via Durtlang Road, then Aizol to Kanmun via Mamit, then Lunglei to Tlabung and Lunglei to Chongte Road. So these stretches of road, these are internal roads, Lordship, which has already been finished.
So your road is, the roads that you are talking about is Aizol to?
Aizol to Kolasip to Silchar via Durtlang, this Tlang
Aizol
Road.
to Kolasip to Silchar.
It is mentioned
via Durtlang.
Yes, Lordship. It is mentioned in Order 13/8/2025. These are the 4 stretches of road.
All the 4 stretches are reflected there?
Yes, Lordship, on 13/8/2025 order. We are highlighting the particularly bad and rough stretches of road here, Lordship.
And this affidavit has not made a mention.
Lordship, I have mentioned
What have you said regarding these?
in a reply to the affidavit in opposition on behalf of the state respondent 1 to 5 additional affidavit. I have submitted 2 affidavits.
Huh? Affidavit dated?
Yesterday I have submitted
Where have you mentioned? Which page?
page number 3, para 5.
3 para 5. Yes? Between Vairente and Sairang. You see, madam,
No, my lord, I have submitted 2 affidavits. One is in reply to the PIL and the other one is in reply to the additional affidavit filed by the petitioners.
okay.
You're referring to the yesterday's affidavit
Yes, my lord.
page, para?
Page 3.
The work will be completed by March 25.
Yes, my lord.
That is for the Aizol scholarship to Silchar via Dutlang Road. Okay. Then the road Aizol scholarship Silchar via Dutlang. Look, your affidavit is nothing. You are basically saying
Yes, my
that due to the constant use of the road, by heavy vehicles carrying so and so, the road condition has deteriorated. The road has to be used. It is for this very purpose that the road has been constructed. And you build good roads. Why do you build bad roads which can be deteriorated? And all these roads, they don't even last one season. Why is the PWD not building good roads? Their excuse is that the roads get deteriorated because constant use by vehicles. That's the very purpose of the roads. What kind of logic is that?
If I may add, Your Lordship, on page 8, Annexure 1, this is Aizol to Durtlang to Lungdai to Konpui Road, up to Konpui Road only. What is going to happen to the road which is beyond Konpui? And they have estimated 35.53 crores to be, and the date of completion is March 2026. And this National Highway 44A, this is Mahmed's site. So the affidavit is incomplete, Lordship. This National Highway 44A is Mahmed Road, and they have, the total cost is 170.96 crores.
Right. Heard Miss Rosalind Elmar, learned counsel for the petitioner, and Miss Caroline L. Nuopi, learned counsel for the state government. You are appearing for whom?
NHIDCL.
And are you involved here?
We have highlighted all the sections under our contract.
Then what about this Lunglei Tlabung Road? This National Highway 302, covering 97 kilometers, is maintained by NHIDCL. I don't know whether you additional AG can take up national highway NHIDCL cases. When the government of Mizoram is also a party. The issue of ethics out there. There might be a clash of interest. है ना? Please think over it, because prima facie doesn't appear to us that you can appear for NHIDCL. And you're the additional AG. Who is the supervising authority? 302 is NHIDCL is the supervising authority, correct?
Yes, my lord.
Then who is the contractor? Looking after 302.
As per our affidavit, my lord, it's the SRK Infra Project Private Limited, who had also engaged BRN Infra Project Private Limited to undertake this work, my lord. My
So,
lord, the
what
thing-
is the status of this 302, 97 kilometers?
My lord, the functioning of the NHIDCL, my lord, if I may explain, it's a public sector undertaking under the Ministry of Road Transport and
Maybe,
Highways.
that much I know.
It's a fully owned company of the government of India,
Maybe
my lord.
it's being this work is being done for the state of Mizoram,
Yes, my lord.
for the benefit of the people of Mizoram.
Yes, my lord.
Now, as the additional AG, it is your duty to ensure that the state of Mizoram has a keen interest in the completion of the contract work. But as a counsel for the NHIDCL, now can we question you with regard to what the state government has been doing in this respect? The state government is the real authority in the state, and it is for its benefit. When is the work going to be completed regarding this National Highway 302? Any affidavit filed by you?
We have filed 2 affidavits, my lord.
And what have you said regarding this 302?
It is at page 4 of my additional affidavit.
What
file,
have you
my
said?
lord. We have said that the estimated which was submitted by the petitioners are incorrect, my lord. Firstly. And that during the year 2023,
Affidavit dated 8 December.
8/12/2025, my lord.
Yes. Para?
Para number 5, page number 4, my lord.
Page 4. It says the answering report begs to offer no comment, as it is the details of the petition in this. But now they have given now the government of Mizoram, through the PWD, has stated that 97 kilometers in 302 is under you. Now, when the government of Mizoram has said that, what is the NHIDCL going to say? That the government of Mizoram has stated a lie?
We've not received a copy of the affidavit.
So we
my
are
lord.
telling you now.
Yes, my lord.
That is why, you see, you have to accept it because you are the additional AG also on the other hand.
Yes, my lord.
You cannot say that this is a lie. So in that case, you'll have to now clarify as to what has happened to this. And this was, where is that affidavit? Your affidavit, wait, this is not even the affidavit of the government. This is the order passed by the court. Let us see the government affidavit. This one, no? Yesterday, 20. Do you deny that you are not having any work in National Highway 302?
I'll have to clarify based on the affidavit
This
submitted by
writ
the
petition
state.
was filed when?
2025, my lord.
Yes, when? Look, this is for the good of Mizoram,
Yes, my lord. I
for the good of the
understand.
state. You are the additional AG of the state. It is your duty to work for the betterment of the state. NHIDCL cannot, stay silent on this aspect. What have I said? This order? I heard so and so, learned counsel for the petitioner. Also heard Ms. Caroline Bloom-Opui, learned counsel for the state government. Ms. Zainab Sapui, CGC, and Mr. Samuel Vanshet Changte for the NHIDCL. The order dated 13/8/2025 passed by this court states that the present PIL is with regard to the dilapidated road condition at 4 stretches within the state of Mizoram, which are, you take this watch, 1, 2, 3, 4, it is here. Okay, just take it down. Next para. The affidavit submitted by the Undersecretary to the Government of Mizoram, affidavits submitted by the Undersecretary to the Government of Mizoram on 20/01/2026 speaks of the Aizol Silchar road via Durtlang, and more particularly the stretch between Sipir to Durtlang. Which they say will be which they say the resurfacing will be completed by March 2025. March 2025? What is this? Yes, madam. There is mistake. March 2026 it should be. Page 3, para 5, last line.
Yes, March 2025. It should be March 2026.
March
Madam,
2026.
This is a clerical mistake.
Bracket, there is a typographical error. As 2025 is to be read as 2026. Brackets 2. The affidavits of the state government dated 20/01/2026 also states that the road between Aizawl, Kolasib, Silchar via Durtlang between Kolasib and Bilkotlir is under the jurisdiction of the National Highway Division 3, PWD, Thingdo. However, the majority stretch of the road is under the jurisdiction of BRTF and NHIDCL. The stand of the state government is that they continuously maintain the road between Bilkotlir and Kolasib. However, due to heavy vehicular movement, potholes have started to develop, which have to be attended to continuously. Next paragraph. With regard to the road condition between Aizawl to Kanmun via Mamit, the state government affidavit dated 20/01/2026 states that the road from Dabchwa to Tuidam is part of NH 44A. The contract work for widening and improvement of the road from KM 11.000 to 114.618 of NH 44A was terminated on 24/8/23. Following termination of contract, the road lacked proper maintenance due to delayed sanction for balance work from the Ministry of Road Transport and Highways. Due to 2 rainy seasons and repeated landslides, the road condition has deteriorated. This was also due to constant use of the road by heavy vehicles. Next paragraph. It is surprising to note that the state government through the PWD has not made any mention regarding the Lunglei Tlabung Road and Lunglei Chongte Road. Which is the responsibility of the state PWD. Next paragraph. It is also surprising to note that the PWD have taken a stand that one of the reasons for deterioration of the road condition is the constant use of heavy vehicles. Full stop. Roads are meant to be used by light and heavy vehicles, subject to the restriction on the load limit made by a state. Full stop. However, in the present case, it is not the stand of the state government through the PWD that the vehicles that have been plying on the roads are in excess of the load limit prescribed by the state. We are not at all satisfied with the affidavits submitted by the state PWD, as they have not taken any steps to improve the road condition and make roads which can last more than one season. If they make roads that they can deteriorate easily due to use by heavy vehicles, they can also take steps for making better roads, as roads are meant to be used by vehicles, light or heavy. Full stop. Next paragraph. The above being said, where is in NHIDCL, where have you talked about the stretch of roads that are under your responsibility? Which affidavit?
The in the main affidavit, my lord, not the additional one.
Let us see.
Page number 5, my lord.
No, your main affidavit is
We have filed two affidavits.
dated?
8/12/2025.
Yes. What have you said?
If I may kindly take your lordship to page 5. National Highway 54, my lord.
Page 5. No, sorry. Page December.
Affidavit submitted by, on behalf of the respondent number 7.
Page 5.
Yes, my lord.
Yes.
It starts from under PMU selling, my lord.
Yes.
National Highway.
We are not talking about Tuipang Road.
No,
What
we have
is-
highlighted all the.
Okay, let
projects
us see. Let us see.
Yes, my lord.
Let us see where you have talked about
Tlabung.
this Lunglei Tlabung Road.
Lunglei Tlabung is in the additional affidavit because it was an additional document.
Let us see where is it. Where is the additional affidavit?
Additional affidavits there in the file.
Of submitted by you,
Respondent number 7, my lord.
dated
8/12, my lord, 2025.
8/12. We have got it in front of us.
We submitted two, my lord, one for the main and one for the additional, together, my lord.
There are two 8/12.
Yes, my lord.
Okay. Where have you mentioned?
Page number 5, page number 4, para number 5, my lord. Page 4, para 5, my lord.
that with regard to the statement made in para 7. You have not said anything.
No, we have stated, my lord, in page 5, the
Ah.
last paragraph, wherein the SRK infra project had engaged one BRN infra project, my lord, and that this BRN infra project had commenced mobilization and initiated urgent road maintenance, my lord, and repair works even before 19/7/2023,
So
my lord.
now it's 26, so what has happened now? Is it complete?
My lord,
You have not said anything whether the work has been completed or not.
my lord, the BRN infra project should be made a party so that they could give.
Mr. Counsel,
That-
you're the NHID, you're the principal of the school.
In that case, if your lordship permits, we'll file another affidavit giving
You
the
have
status.
to, you have to.
Yes, my lord.
You have to clarify. Otherwise, next time your head honcho will have to come here
We'll
with all the
clarify, my
files.
lord.
You file it within 2 weeks.
Yes, my lord.
What is this? This petition has been filed in 2025, in June or whatever. And this is the working season. You have to complete it now. You've got just 2-3 months left. Right. And what about, and others you don't have any responsibility, huh? Only with regard to Lunglei Tlabung.
At page number 4, my lord,
Yes.
of the same affidavit,
Yes.
the total stretch, point number A, my lord,
Yes.
the total stretch of 39 kilometers between kilometers 54 to kilometers 70 and 95 to 118 was under the jurisdiction of NHIDCL, on which STMC works were awarded to SBCC. The physical progress of the work is 96.84 and
Okay, it's already done.
yes, my lord.
Yes, madam? Yes?
Yes, Lordship.
They have said that 96.84% has been done and 91.29 has been done.
This is with regards to which portion, Lordship? It has not been mentioned regarding the stretch between kilometer 54 to 132. This is under which NH?
Yes, you see one thing, this 96.84 and 91.29 pertains to SBCC. And the work is supposed to be done by BRN, Infra Project Private Limited. So this SBCC is different.
This is
Work
a different stretch of road, my lord.
So what about the work done by BRN Infra Project Private
That will
Limited?
file another affidavit, my lord,
Then?
with regards to Tlabung, my lord.
That's what we want, only Tlabung.
Tlabung. We'll file, my lord, within 2 weeks.
Right. What have I said? No, before that, what did I say? Okay, the above being said, the affidavit, the reply to the additional affidavit dated 8/12/2025, made by the respondent number 7, is to the effect that everything is very unclear. No? Which work they have done here. I think we'll call who's your head person here? We'll call him here. With all the files, let him come. This is not the way to, you are trying to hide facts. You have got to be clear in your facts.
We'll clarify all of the work and the stretch and the status, my lord.
What have I said? Is to the effect that work under the is to no, it's not is to the effect that is to the effect that work has been allotted to MSBRN Infra Project Private Limited, while letter dated 19/7/2023, and that the work is to be initiated. Because director submit a quotation and that work has been initiated. The affidavit also speaks of a stretch of 39 km road being awarded by NHIDCL to MSSBCC. Which is nearly complete. However, the affidavit of the NHIDCL is unclear as to which stretch of road, which national highway or road or particular road is being repaired or constructed by them. Unless a clear and unambiguous averment is made by the NHIDCL, it is difficult for this court to decide as to which road the NHIDCL is working on. Accordingly, the NHIDCL shall submit an affidavit within 2 weeks, making specific statements with regard to whether it has got any role to play in the 4 stretches of roads mentioned in the earlier part of this order, and specifically state whether the stretch of road under National Highway 302 bracket Lunglei dash Labung Road, comma, under the NHIDCL has been completed or not, or the present status of the same. Next para. The state government, the state government through the PWD shall also file an affidavit positively within 2 weeks with regard to all the 4 stretches of roads mentioned in the earlier part of the order, and specifically state the approximate time of completion of the repair work for the roads. The CGC, yes, what is your role, madam?
Madam, we are just a northern ministry, madam.
Huh?
We are just a northern ministry.
You are just a nodal ministry. And what do you do? Just sit back, relax, enjoy the food. What do you have got to do? You have got to do some work also, madam.
We didn't receive specifically instruction in this regard because the work has been done through NHIDCL.
Is the BRTF a part of this PIL?
However, DRTF is not yet a party now.
We have not made a party, Lordship.
Neither am a party. You see this order. Not this order, wait. The affidavit of the
State,
government,
the state government.
Page 4, page 4.
yes, Aizol, Kolasip, Silchar, via Dutlang. The stretch between Kolasip, Bilkotli, says so, read from 70 to this is para 4,
Yes,
no, page
Lordship.
4, top, that the road mentioned between Aizol, Kolasip, Silchar, via Dutlang, covers so are mostly under jurisdiction of BRTF.
Yes,
NHIDCL.
Lordship. Yes, Lordship.
Okay, right. Next para. What have I said? The CGC appears for MORTH. Huh? And she has been informed that para 5 of the affidavit of the state government dated 20/01/2026 states that the stretch of road between Kolasib, the stretch of road between Aizol, Kolasib and Silchar via Dutlang, covering 180 kilometers, is mostly under the jurisdiction of the BRTF and NHIDCL. Accordingly, the NHIDCL shall also make specific averments with regard to the above stretch of road in their affidavit to be filed within 2 weeks. Further, as BRTF is a necessary party, they are implemented as respondent number
8, Lordship.
8. The BRTF, which BRTF? Pushpak. BRTF Pushpak. BRTF through Pushpak. Huh?
Lordship.
Through what? It will be through the chief engineer Pushpak, no? Through the chief engineer Pushpak. Through the chief engineer project Pushpak. Zemabok, Aizol, Mizoram are implemented as respondent number 8. Petitioner to submit a corrected copy of the cause title
Yes, Lordship.
to the registry of the court. Miss Zairem Sangpi CGC accepts notice on behalf of the respondent number 8. She is also directed to file an affidavit within 2 weeks. Madam, be serious. This one. No. 2 weeks. If they don't come, I'm going to call your head. She is to file an affidavit within 2 weeks regarding the stretch of road that is the responsibility of the BRTF on the Aizol, Kolasib, Silcha via Dutlang road. This is the matter. On, give a date.
Lordship.
11 February.
These are things that are important for the state.
Item 2.
Please, my lords. My lords, as per instructions, the comments are under vetting under the law.
No, it is a simple thing.
They've-
Has the state wetland authority been constituted? That's all.
Yes, my lord. If your lordship can give us 1 week's time, my lord,
No.
to
Mr.
file the
Kaur,
affidavit, my lord.
no need of affidavit. You just ask the court, you just ask your officers, the forest department, whether a state wetland authority has been constituted. Once that is done, then the job of this court is over. There's nothing else to be done. That's all. You just ask them.
Yes, my
In
lord.
your affidavit, what are you going to say? that there is a wetland, there is a, that there is a, what do you call it? The
Ramsar site.
huh? What site?
Pala wetland, sir.
Ha. Yes, please. Yes. You see, this Ramsar thing is that Pala.
Yes, my lord.
You see, it is in South Mizoram. It is in Siaha, I think.
Yes, my lord.
So, it is it's just that when there is a Ramsar site, it has to be looked after by an authority to be constituted by the state
Yes, my lord.
under the statute, under the rules, 2017 rules. Now, once that authority has been constituted, this court has nothing to do,
Yes, my lord.
because everything will be looked after by them. That's all. Just find out.
Yesterday,
Call them up.
upon communication, my lord, they told me they had sent me an incomplete parawise. That is why I'm asking for slight.
No, that's all right. You
Yes,
see,
ma'am.
there is no requirement of. You are the additional AG.
Yes, my lord.
If you can tell us that yes, it has been constituted, or it is going to be constituted within so and so, end of the matter.
Yes, my lord.
Why do you need a parawise comments to tell us that? That's the only thing. Because under the conservation, wetland conservation and management rules, 2017, this has to be constituted. That's all. So the Supreme Court only wants that the authority is constituted. And it's not that they're going to be given cards or the authority would be made up of your officials only,
Yes, my
as
lord.
per the rules. Just find out, 10 minutes, you can just ask them 10-15 minutes during the course of the.
Yes, my lord.
Item number 3.
My lord, here,
Yes.
my lord, writ petition was dismissed on the maintainability, my lord. Because, my lord, as per my lord, the learned single judge, my lord, this is, my lord, against the order of the civil court, my lord. So I approached this honorable court. But fact is that, my lord, initially, my lord, there was, my lord, the reference court order, my lord. Reference court order, the respondent, in writ petition, they were the party, my lord, reference court. Thereafter, one CMA was filed, my lord. In CMA, my lord, they are not party, my lord. The other person, they are party. So in CMA, the person, they asked for interest under section 28 and 34, my lord. And CMA was disposed with direction to pay the section 28 and 34 of the State Act, my lord. And thereafter, my lord, the private respondent.
So, there was a acquisition of land.
Yes, my lord.
Award was passed.
Yes, my lord.
The landowners not being happy with the market value,
Yes, my lord.
they approached the.
Land value was 0, my lord. So they.
So, because no land value is given,
Yes, ma'am.
they approached the reference
Yes, ma'am.
court. Now, reference court has passed an order.
Yes, my lord.
So, it had allowed the reference.
Yes, my lord.
Now, you put a challenge to that.
No,
by-
my lord, I have not, my lord. We paid that amount, my reference
Then?
court order, my lord.
Huh.
Reference court, the excess amount, this fixed, my lord, reference court, my lord, the land value, my lord, we have already paid, my lord, that amount. Thereafter, my lord, there is no order to pay under section 35 and 28 in reference court order, my lord. So, my lord, some petitioners, some landowner, they approached again reference court by way of CMA, my lord.
How? Once the.
Yes, my lord. And thereafter, the CMA, in CMA, order was passed to pay.
But it is a disposed of case.
Yes, my lord. This,
Functus official.
yes, my lord. And thereafter, on the basis of the CMA order, my lord.
So you filed a petition under 226 or 227?
226, 20, both it was there in reflected in
227 also. was
Yes,
there.
my lord. So, my lord, single judge, my lord, the submission of the private respondent was that, my lord, they filed a CMA, my lord. But they never filed a CMA. Some petitioner filed CMA. On the basis of this, that, my lord, this, the petition is.
No, you see, so CMA Some other persons filed CMA.
Yes, my lord.
And they got the 28 and 34.
There is order, but no, not paid, my lord, because there's not paid because there is some cases.
I'm not on that.
Yes.
So an order was passed
Yes.
by the reference court
Ye-
on the basis of that CMA.
A reference code from after filing CMA, my lord, they passed an order for pay 28 and 34, my lord.
That's what I'm saying.
Yes, my lord.
So you have not paid that.
Yes, my lord, because some cases pending by the principal settles, my lord, regarding 28 and 34. Your lordship was sitting, my lord, in Article 8 up to dear my lord. Chief Justice was there, my lord, here, my lord, that case, my lord. So,
Anyway, that is one
Yes,
aspect.
yes.
Now the other aspect of the matter is that with regard to these respondents, these
Yes.
landowners,
Yes, madam.
they did not file CMA.
no, my lord. The,
What is the CMA number?
CMA, it is, and the judgment itself reflected, my lord, CMA number, my lord. Now, 90 CMA is, my lord. CMA is 92 of 2019, my lord.
2019.
Yes, my lord.
Reference case number is?
Reference case number is, my lord. LA case is, my lord, 19 of 2013, my lord.
LA case number 19 of 2013.
13, my lord. Yes, ma'am.
And this LA reference case number, this LA case number was disposed of on
My lord, immediately dispose of, my lord.
date.
Yeah, I am giving it, my lord. It was, my lord,
You should make a list of dates.
yes, my lord. It was disposed of 6 March 2014, my lord.
6 14. And CMA case number 92 of 2019 disposed
It
of
was
on
disposed of 5th April 2019, my lord.
5th April 2019. Were you party there?
My lord, railway is the party, my lord, in CMA.
So you are a party there.
Yes, my lord.
Now the award was award number, initial award.
Yes, award number 1 up to 2012, part E of Malkhang, my lord.
Part E.
Yes, my lord. It is page 39, my lord.
Part E,
Malkhang.
part, page 39.
Yes, my lord. Reference code order, my lord. Paragraph 2, my lord.
Mr. Counsel, part page 39. Malkhang, not Malkhong, Malkhang.
Sorry, my lord.
Malkhang. When was this award pronounced?
My lord, the award was pronounced, my lord, on 28 January 2013.
28/1/13. So these persons who prayed for 28 and 32,
Yes,
34,
Yes, my lord.
34, no?
Yes, my lord.
Under CMA 92 of 2019, they have been given the money or not?
No, my lord.
Not given.
No, my lord. So,
Then that case is under appeal.
some cases I have no instruction, my lord, but what happened, my lord, there's so many appeals pending, my lord. 4 appeals pending. Now it is before a principal, my lord. So,
So anyway-
because our plea is, my lord.
No. Then how come these private respondents here in this case?
Yes, my lord.
How did they applied for, they filed a writ petition or what?
No, my lord, they filed the application before the district collector, my lord.
Application dated?
Yes, my lord. This application is dated, my lord. It is page 56, my lord. Page 56.
Dated? No date.
No date, my lord.
So dated nil.
Nil, Lord.
Then where is the impugned order?
Yes, my lord. Impugned order is, my lord, page 67. It is passed on 22nd November 2022, my lord.
But this is only under 34.
Yeah, my lord. Yes, my lord.
They have not claimed under 28.
My lord, is the order, my lord, reflected in page 69, my lord.
Yes.
Page 69. From above, and last paragraph, from above, some factions, I am
Okay,
satisfied.
34.
Yes.
28 and 34. Dated 22/11/22. So you put this to challenge.
Yes, my lord.
On what ground?
My lord, this only 34 and either 34 or 20,
Or 28.
28, my lord. And initially, when I represent file, my lord, this the Euroship person of stay order, my lord, initially, my lord. Stay order is there, therefore it was continuing, my lord. After, my lord, this my submission was some relatively pending regarding this seed issue, but in affidavit filed by the private respondent, there is no such plea that it is not maintainable. But in oral submission, it is not maintainable. It's on particular day, my lord, it was, my lord, they submitted some judgment.
Okay, no, anyway, so according to you, you have given interest under 28.
Yes, my lord, we are ready to give one interest, my lord.
Okay, you are ready to give one interest,
One
not
interest.
two.
Yes, my lord.
So you said that there is a similar case pending before this court. What is the case number?
My lord, in principal seat, my lord, writ appeal pending, my lord.
Writ appeal number?
265, 2023. And writ appeal number 8 of 2024 also, my lord.
Writ appeal number 8 of 24.
Yes, my lord. Your lordship was there, my lord, when this order was passed, my lord.
What is the other number? Writ appeal?
265.
23.
It is pending before principal bench, my lord. It was fixed on its, my lord.
Okay, that is one.
Yes.
Now, so you put this to challenge, this impugned order,
Yes, ma'am.
in the writ petition.
Yes, my lord.
And the single judge held that
Because
since it is a appeal from a court, judgment of a court,
yes, ma'am.
you have to file an appeal, not a writ petition.
Yes, my lord. And that CMA, my lord, this private respondent was not party, my lord. So, my lord,
So it is not binding upon them.
yes, my lord. Only this consider that, my lord. This,
Okay. Who's for the other side?
my lord, the other said notice not got, my lord.
Okay, right. Heard Mr. S.K. Medi, Learned Counsel, Learned CGC, appearing for the Union of India. The appellants have prayed for setting aside, have challenged the impugned judgment and order dated 3/11/2025, passed by the learned single judge in dismissing WPC 57 of 2023 on the ground that
It's not included.
but just a minute. 56, no.
Mainly with the.
But this is not a reference court. This is impugned order is not a reference. It's not
Yes,
CMA.
my lord. Impugner is not same.
It is not a the order of the court.
No, my lord. It is my plea, my
It
lord.
is a correct.
Yes, my lord.
It is CMA is not put to challenge.
My lord,
Impugned order has been put to
yes, my lord.
challenge.
So, paragraph 18 of the judgment, my lord. However, Mr. Medi, learned CGC for the petitioner has tried to convince this court that petitioner have challenged the order of the district collector, so and so, date so and so, not the order of the learned reference court. Yet, the submission of Mr. Medi left this court unimpressed.
Okay, anyway, what have you said? No, passed by the? On the ground that an order of a civil court was not amenable to writ jurisdiction under Article 226 of the Constitution of India.
226 and 227 also, my lord, according to.
Where is your petition? Let us see your petition.
No, my lord,
Let us see your writ petition. Where does it say 227?
227, but it is there, my lord.
No, you've got to mention it.
You have not mentioned, my lord.
Then?
Yes.
No, 226. Pustak. Next para. The facts of the case is that award number 1 of 2012 had been pronounced by the district collector on 28/1/2013 for award number 1/2012 bracket part E dash Mualkhang bracket close on 28/1/2013 for payment of compensation for the lands acquired by the respondents herein, amongst other land holders. Full stop. The landholders, being aggrieved with the market rate of compensation, they filed an application under Section 18 of the Land Acquisition Act 1894, hereinafter referred to as the LA Act 1894, for reference. The district collector sent the application to the district civil court. Wherein it was registered as LA case number 19 of 2013. LA case number 19 of 2013, next para, was allowed by the learned reference court via order dated 6/3/2014 by enhancing the market value of the acquired lands. First, the enhanced compensation value was thereafter paid by the appellants to the landowners. When?
My lord, to 2015 itself, my lord.
In the year 2000. This is orders of 2014.
Yes, my lord.
So when did you pay? 2000?
15, my lord.
In the year 2015. Next para.
My lord, 27 January 2015.
27 January 2015. Next para. Thereafter, some of the land owners in award number 1 of 2012, excluding the present respondents, filed CM application number, civil miscellaneous application number 92 of 2019 before the learned reference court, which had disposed of LA case number 19 of 2013, praying for payment of interest under section 28 and 34 of the LA Act 1894. The learned reference court, which had become functus officio due to disposal of LA case number 19 of 2013, allowed CMA application number 92 of 2019, via order dated 5/4/2019, by directing payment of interest to the applicants in CMA number 92 of 2019 for payment of interest under section 28 and 34 of the AL Act 1894. Full stop. The same has been put to challenge. That CMA order has been put to challenge. CMA order?
I have not challenged. I have challenged the DC order, my lord.
No. In WH 265 and 23 and WH 28 and 24, the WH that is pending in the principal seat, this CMA has not been challenged.
Not challenged.
Full stop. Next para. The order dated 5/4/2019 passed in CMA 92 of 2019 has not been put to challenge. Has apparently not been put to challenge till date. However, full stop. The above being said, the present respondents thereafter filed an application / representation dated nil to the District Collector Colosseum. Don't say represent, say application. Praying for payment of interest under section 28 and 34 of the LA Act 1894. In pursuance to the order dated 5/4/2019 passed in CMA 92 of 2019. Next para. The district collector thereafter vide order dated 22/11/22 allowed the application of the present respondents and awarded payment of interest under section 28 and 34 of the LA Act 1894. Full stop. Next para. The appellants being aggrieved with the order passed by the district collector for payment of interest while the impugned order dated 22/11/22 put the same to challenge in WPC 57 of 2023. The learned single judge, while the impugned judgment and order dated 57, the impugned judgment and order dated 3/11/2025, dismissed WPC 57 of 2023 by holding that the order of a civil court was not amenable to risk jurisdiction under Article 2 to 6 of the Constitution of India. Next para. The learned counsel for the appellant submits that the impugned order dated 22/11/22 passed by the district collector is not an order of a civil court but an order of a district collector. Full stop. Further, though the district collector may have applied the decision of the learned reference court in CMA 92/2019, the same could not be applicable to the case of the respondents hearing, who are not party who are not parties in CMA number 92 of 2019. In any event, when the order of a district collector cannot be said to be an order of a civil court, there was the learned single judge erred in treating the order of a district collector as an order of a civil court. Full stop. Admit the appeal. Issue notice returnable in 4 weeks. Are you a party there, madam?
8 and 9 state
Oh,
is made a
8 and 9, huh? 8 and 9. Acha, those other respondents come 1 to 7 there. 1 to 7. Mrs. Linda L. Fumble, additional AG, Mizoram accepts notice on behalf of respondents number 8 and 9.
It's completely based on the CMA.
Same, completely based on it. But it's still an order of the. He could have heard it on merit. The repetition. What do you say?
So, we'll admit it.
What have I said? It's 8 and 9. Appellant to take step for service of notice upon the respondent's number
There's
1 to 7 by speed post within 3 days.
7 days, my lord.
Huh?
7 days, my lord.
7 days, okay, within 7 days. List the matter on
My lord, if my lord February, my lord 23rd possible, my lord, or
23rd February. Acha, one thing you're right, huh? Before you admit, you're right. The learned counsel for the appellants also submits that. The appellants are willing to pay interest.
that may not.
No,
But that may not.
that's what you said.
Yes, my lord, but it is only one interest will pay, my lord.
That's what I'm saying.
My lord, I will pay.
You'll have to pay one. Not the
No,
other.
we'll definitely pay, my lord. We'll definitely pay. But that is the case, my lord, NDPS 8 of 2023, my lord, 24, my lord. On that day, I was also there. Lordship was there. Chief Justice Harish Gupta was arguing the case, NDPS, my lord, here, my lord. When Chief Justice was coming, my lord. And they discussed everything, my lord. And so it was transferred to Chief
Okay,
Principal.
right. The appellant's counsel submits that the issue of payment of interest under section 28 and 34 of the LA Act 1894 is also pending in the principal seat in WA number 265 of 23 and WA number 8 of 24.
Yes, my lord. My lord, 3rd of February fixed, my lord, this case.
Which is fixed for 3rd February 2026.
My lord, in the meantime, the order may be stayed, my lord.
Okay. Till the next returnable date, the impugned order. How does it matter?
My lord, single just, my lord,
The contempt.
contempt file, my lord, another will.
Okay. Till the next returnable date, the impugned order shall remain stayed.
And as well as the assessment of the DC order, my lord, 22nd, this order, my lord, 22nd November 2022, that order, my lord.
Yes. As well as the, but then there cannot be any contempt on that.
Well, maybe, my lord, because in some cases we find.
You all might want to pay also, how do you know?
My lord,
Impugned order is enough. Single judge. Impugned order is enough.
and there are only one line, my lord, that.
What will happen? They can only file a writ petition
Yes.
for implementation.
Yes,
That's all. No need.
as your lordship. Highly obliged, my lord.
Item 4.
Okay, right. This is a jail appeal. Against the impugned judgment and order dated 22/2/2019, passed by the District and Session Judge Lunglei, Judicial District, by the DCA Session Judge Lungle, huh? In criminal trial number 172 of 2017, by which the appellant has been convicted under section 302 IPC. Admit the appeal, call for the TCR, registry to appoint a legal aid counsel / amicus curiae. List the matter on date 4 weeks.
18th of February.
18 February.
Item 5.
Let the TCR come, paper book will be made. Item?
Item 2, my lord.
Oh, yes.
If your lordship will allow me to produce the extract copy of the management plan, my lord. They have it.
Okay, they have made it. I think that's the end of the matter. You show your brother, your colleague. No, but where is the, this is the management plan.
Yes, my lord.
Where is the constitution of the authority?
If your lordship can give me a day's time, my lord.
No, you file a comprehensive thing.
Yes, my lord.
Yajuban, this plan is only till last year.
This is only till
Yes, my lord.
24, 25. Now it is 25, 26.
Yes, my lord.
To me, 25, 26, 26, 27. So you see what you have got to give. You give the exact area of this Ramsar site,
Yes, my lord.
this Pala wetland, and the steps that you are going to take in the future. Okay.
Yes,
For ensuring that this wetland remains the same, and how to improve it. You have got to think of ways to improve it. I went to this Palak deal, they call it.
Yes, my
Now out it's Pala. So is it Pala or Palak? Mr. Janari? Pala.
Pala.
It should be Pala. 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 Okay. Anyway, out there they are still saying this Palak, but it's Pala. Even Tongkolong is not Tongkolong. It is Tongkolong. Yes, Tongkolong. Because in our younger days, these government officers used to, threaten each other, and there was a joke that if you don't perform well, you will be sent to Tongkolong. So it's the furthest village where a government office is situated. So I went there this last week only to see that place because of the name. And I went to this Pala lake also. I took a boat ride also. Beautiful lake. Beautiful lake. So you have got to make an authority. An authority has to be constituted as per the rules, 2017 rules. You just look at the orders passed in this case.
Yes, my lord.
Look at the orders. You make an authority as per the rules, and then you make a plan with regard to the area of this wetland. There are many birds there. Different birds are there also. So there is a forest guest house there. I mean, you cannot stay, though there is a room where you can stay, but it's not usually given out. There are 3-4 persons already there. There are 2 boats with with engines, and it's a nice place. So just so you'll have to write in an affidavit what is already there, how you're trying to improve, and how you're trying to improve the ecology of that area. Fishes in the lake, though I do not know, the chowkidars might be having a feast, but it's a big lake.
Yes, my lord.
So that is there, and birds, natural conservation of birds, then improvement of the communication to that place. It is just half an hour from Pura. Just half an hour from Pura. Anyway, right. You see, because we are crossing the time limit. We have already crossed the time limit. Right. Mr. Samuel Barnes said the Changte Learned Council, additionally, submits that he will take up the issue of constitution of the State Wetland Authority in terms of the wetlands (conservation and management) rules 2017, which has an area of approximately 1850 hectares. The state government shall submit an affidavit stating the present status of the Ramsar site, Ramsar site, and the steps that are being envisaged for improvement of the said wetland. keeping in view that the ecological balance to be maintained, should be for the better, as no, and recommend mechanisms for maintenance of its ecological character through promotional activities. List the matter on when? After 2 weeks.
11 February.
Oblige, my lord.
Supplementary list for admission, item 7 and 8.
Six ka dilo no? Six ka na dige.
6 is not agenda.
Supplementary nominee.
Okay, that's it. Oh.
Hearing around. My lord,
7, 8.
my lord, if it can be taken up in the afternoon, my lord. All the documents are found except 6 documents, connected documents, so they are still taking time.
Okay, we'll take it up at 2.
Item 9.
Depending upon single bench, after single bench,
Nakto ati maila.
Or it can be taken up tomorrow, my lord. I'll have a time to go through also.
what you can do is, okay, we'll take it up at 2. Yes, we'll see.
With your permission, my lord, if your lordship will allow me to produce a letter dated 9/1, communication letter dated 9/1/2020.
Item?
9, my lord. Regards to the
District Court.
District Court Lunglei, my lord.
Ha.
The first letter is by the Under Secretary to the Government of Mizoram, my lord, GAD. And the next letter, my lord, is addressed to the District and Sessions Judge, my lord, Lunglei.
Okay, right.
District Judge.
Mr. Samuel Valarthiyata, the additional AG has submitted letter dated 9/1/26. No, 2 letters dated 9/1/26 issued by the Under Secretary to the Government of Mizoram, GA, General Administration Department, which are as follows. No, out here. Which are as follows. No, which are reproduced here, which are made a part of the record and marked as annexure X and Y respectively. The contents of annexure X and Y are reproduced here below as follows. Okay, you make it X, so and Y. Just do it. Actually, this is also wrong. It has to go through the registry actually. Yes. You are appearing for?
My Lord, I am appearing on behalf of the respondent number 2, MBA.
The bar.
Bar.
So you all want that place. I think we have also given approval.
That,
The High Court also has given approval, I think.
that aspect, that information still that is not in my knowledge, my Lord. Till
Yes, who is for the High Court?
I'm for the High Court.
I think the High Court principal seat has given approval for
The present proposed land.
has given approval for exchange. So haven't you asked?
You'll have to ask the registrar then.
Then just ask him. We'll take it up at 2, because we have got to write down everything. If you can have that approval of the High Court, then we can put it. You just you do this, whatever. Then we'll carry on with the order. I think we've already approved. Because the plot that the bar has now pointed out, identified, it's a very good plot. We have been given the earlier plot. This is a better plot, so now we are becoming greedy, so we want a better plot. Naturally, no? Yes.
Item 10.
May it please your lordship. This writ appeal is for challenging the judgment order dated 13/8/2024, passing passing WPC 96.
Yes. You were
2010.
saying something.
Yes, my lord, if your lordship can kindly allow me to adjourn the matter, because I have personal difficulties. I am prepared.
So after I was planning to dispose of this matter today. Unfortunately, yesterday after the IA, he comes with a wedding invitation.
That is not.
So,
But
now,
my lord, I have a citation recently. Citation 13/1/2026 is cover all the matter, my lord.
no, but then you see.
Okay, my lord.
Let
Yes, I
us see a
understand.
citation. Let us see a
Yes.
citation. So how can we deny
Oh, my lord,
his
I
request
understand.
when he's getting married next week?
I'll be.
We have got enough on this is which I put at the same. You see, there's another aspect. Even if supposing the respondent number 1 is not eligible, but then the respondent number 2 and 3 are eligible. Of course, if they are, have you got any daughters? Has
One
done-
daughter, one son, and one
daughter is
daughter.
married?
Not married.
My lord,
Then-
the disabled son. We are
Disabled
ready to
son.
Oh,
make
disabled
for-
son.
Yes, my lord.
No. Not only disabled son, madam.
My lord,
An unmarried daughter till her death is entitled to family pension.
Yes, my lord.
Whatever be her age. Maybe 90 years old also, but entitled. So, now the issue is this. If the first wife is alive and there is an unmarried daughter or a disabled son,
Yes.
then they'll have to share 50-50, even if the second marriage is void. Because under section 11 of the Hindu Marriage Act, it is a void marriage. When there is a marriage, second marriage during the subsistence of the first marriage. However, if the first wife has expired,
My lord.
then they are entitled to everything.
Yes, my lord, my instruction is that the first wife must have been.
So you get
passed
the
away.
information, you file the extra document. In the writ appeal, these are new developments, you can always file it.
My lord.
Right, on the prayer of the counsel for the respondents number 1, 2, 3, who is going to
My lord.
get married in the next week. The matter is adjourned for how many weeks?
3 weeks, my lord.
3 weeks.
Highly obliged, your lord.
For hearing, item 6.
May I please, Lordship? Lordship, I got the instruction from my clients that, Lordship, certain documents need to be filed, Lordship, to bring on record for the development of the case, Lordship.
What documents?
Uh,
There's nothing.
Lordship, we might need to challenge the opinion of the election commission, Lordship.
Huh?
We may need to challenge the opinion of the election.
You have to challenge that. You have to challenge the governor's orders also. You withdraw this writ petition and file afresh.
My lord-
You see, I'll tell you why.
Lordship,
There is this judgment also of the High Court of Meghalaya,
Lordship,
exactly on that issue, where the order of the governor and the election commission was not put to challenge.
Lordship,
So the court held that so far as respondent number 10 is concerned, the Honorable Governor had passed the order on so and so, on the basis of the opinion of the Election Commission on so and so. True it is that this court had earlier deferred the matter awaiting the decision of the Honorable Governor, but thereby it cannot be assumed that this court kept the challenge to the order of the Governor also open to be taken up in this petition as framed. We are clearly of the view that if at all any challenge is sought to be taken up by any person against the said order, that is a fresh cause of action to be strictly taken up in accordance with law. There is no so-and-so, there is no quarrel with the proposition so-and-so. We see no reason to grant the prayer for amendment of this petition because, as noticed, any challenge to the order dated so-and-so is a matter of fresh cause of action, where the cause, if at all, has to be taken up on different parameters and the scope and extent of inquiry is also different. So you withdraw this writ petition.
Lordship,
and
I might be allowed 1 day, just 1 day, Lordship. I will take instruction.
you take instruction or we dismiss it on merit. I mean, we decide on merit.
Lordship, that same objection is taken by me in paragraph 4.
I know, it's already there. It's already there. It's
That's
already there.
If matter may be post for tomorrow, Lordship.
Yes. And in this case, which the election commission used
Agnes Kharsing.
disallowing the prayer of the council. So I know this. 2013. In fact, me and each other, we were together.
Lordship, your Lordship is reading from that Agnes Kharsing's case. Srimati.
Ha ha ha.
Lordship, I will take instruction and Lordship.
That's the best course.
Lordship.
No adjournment.
Lordship.
Either you withdraw tomorrow with with liberty to file afresh,
Lordship,
that we might allow,
Lordship,
otherwise we'll dispose on merit.
Lordship. Humbly obliged, Lordship.
On the prayer of Mr.
B. Chakma,
B.
Lordship.
Chakma, counsel for the petition, list the matter. Petitioners, list the matter tomorrow.
Humbly obliged, Lordship.
Item 11.
Item?
May it please your lordships.
Huh? Yes, what is your case?
My lord, we are challenging the order passed by the learned single judge of this honorable court dated 16/11/2023, wherein the writ petition filed by the instant respondent number 1 was allowed without affording opportunity of filing us objections, my lord.
Yes.
My lord, if I may kindly take your lordships to my affidavit in opposition, your lordship. And in that annexure, I have annexed, first of all, the orders passed by the single judge, wherein time were given. My lord, if I might take your lordship to the first order in the writ petition, page 11.
Page 11 of the affidavit of opposition.
Yes, my lord. This is the first order passed in the writ petition.
Yes.
And at page 12, your lordship, Mr. P.C. Lalthangmoya, the learned government accept notice on behalf of respondent 1, 2, and 3, while Zarim Sampui, learned CGC, accept notice on behalf of the respondent 5 and 6. And Mr. Samuel Valnashi accept notice on behalf of the respondent 7 and 8. Now, respondent 7 and 8 is the appellant here. And your lordship, in the next order, we'll see that it is only regarding respondent number 4, which notice was awaited. And my lord, if I take it to the order on 5/10/2023, again, your lordship, on the second paragraph, the learned counsel, page 14, your lordship, appearing for the respondent today submits that they may be granted 3 weeks' time to file counsel.
No, so this.
And
so,
again, your lordship, they were given in the last paragraph of the order.
No, so the first time they were given a chance
Yes.
was in August 23, 22 August 23.
Yes, 22 August,
And it was disposed of on 16 November
16 November.
23,
Yes.
within 3 months.
My lord, if we see the order, my lord will see that the Kala we have submitted a, my lord, if I'll take you back to the facts, small facts.
No, your facts is that your land was in the award, correct?
My land was in the notification, in the declaration, in the award, possession was taken, and in the award, all the P-Pata, I'm a P-Pata holder, all the P-Pata holders have been given land value. And my lord, only me was left out in that award. And I have filed my RTI, your lordship. If I may kindly take
Now
your
they don't want the land, they say that it does not touch your land.
No, in the RTI, we have asked the Kala, why am I not given? First of all, we have asked whether all the P-Pata holders has been given land value, and the answer is yes.
There is a judgment passed by me, I think, recently, regarding regarding when the notification is issued. I do not know whether it is here or in Guwahati. And then then the ultimate requirement is that they have to pay.
Yes.
I think that is there, but I don't know if it's here or where is it.
In a similar matter, I have two judgments.
Only one problem. I'm not on the merits right now. They have to be given a chance. If they go to Supreme Court, 100% Supreme Court is going to send it back.
My lord, the issue
So you
here,
want to delay the matter or?
my lord, I have a judgment here. The issue here is the question here is whether after the land has been acquired, all the proceedings of the land has been acquired, whether that land which has been vested to the central government can be divested Again, even if it's not used for the purpose.
Correct.
So the Supreme Court has said in the negative, Your Lordship, if I may take it to the judgment, V. Chandrasekharan and others, I have earlier given.
No, there is one judgment of mine also in Guwahati, I think, or somewhere. I think under the National Highways Act.
Yes. And in Shimla, Your Lordship.
So
Shimla
that way,
High Court.
merit-wise, I don't, that's why I'm saying,
My lord.
I'm not on the merit.
My lord.
I'm on the issue of not them being given opportunity to file an affidavit. 3 months' time only, I mean, what do you say?
My Lord, in the last order of this court,
What has happened was, August they filed
2012,
single that disposal 3 months later. And of course, they did not file the affidavit. So they think that we should have been given opportunity to file the affidavit. This is not CTCD petition. I'm not on the merits of whether he should or not he should. Because that some more time we have been given. I'm not on the, we're not on the issue of merits right now, basically. It's on the issue of, you see, that 3 months' time.
My Lord, in the, on page 15, the order dated.
What have you, what is your case? You have put it here?
Yes, my lord. My lord.
So if you have put your case here in the appeal,
Yes.
so no need of filing any affidavit in opposition now?
No, my lord.
So we can decide the matter?
Yes, my lord. That can be decided.
So what is your case?
My lord, in fact, as soon as we received the notice issued by this honorable court, in fact, this case was filed on 18/8/2023. And as soon as we received the copy, we have intimated a letter dated 05/09/2023. This is at page number 158. We have intimated Kala that the land of the respondent number 1 herein was no longer required, and that
Oh,
yes, and that
where is that letter? Page?
this is at page number 158. 158, annexure number 6.
When was the award passed? When was that notification issued? Under what, 3G or no, 3D or
3D,
what?
my lord.
Huh?
3D. 3D notification.
3D.
Yes.
Here's the National Highways Act. We have to see whether which comes earlier in point of time. Yeah. 3D. The Declaration of Acquisition.
Your Lordship will see at page number 69. Page number
69?
Yes, 69.
No. So this 3D declaration was made when? Date?
10/10/2018.
10/10/2018. This is at page number 69.
10/10/18.
Yes.
18.
Then
Page number 69, and at page number 19, the name of the respondent, private respondent number 1, herein was reflected at serial number 314, at page number 70.
look, so when did you say that you do not want the land?
My Lord, if Your Lordship could kindly come to page number 158. Page number 158. We have stated our reason.
Whatever be the reason, I said the date.
Yes.
When did you first inform the Kala or any other
On
authority?
05/09/2023.
5/9/23.
Yes.
Then where is your case?
My Lord, the competent authority had extended time
For?
for completion of the work.
No, that's
On-
not the issue.
Yes,
Have you read 3D?
my Lord.
Please read. What does it say?
Where no objection under section subsection 1 of section 3C has been made to the competent authority within the period specified therein, or where the competent authority has disallowed the objection under section 2 of this section, the competent authority shall as soon as may be submit a report according to the central government, and on receipt of such report, the central government shall declare by notification in the official gazette that the land should be acquired for the purpose of purposes mentioned in subsection 1 of section 3A. Number 2, on the publication of the declaration under subsection 1, the land shall vest absolutely in the central government free from all encumbrances. Number 3, where in respect of any land a notification has been published under subsection 1 of section 3A for its acquisition, but no declaration under subsection 1 has been published within a period of 1 year from the date of publication of that notification, the said notification shall cease.
No, you come to 3D2 again.
3D2.
Don't just rush through. Just read carefully.
On publication of declaration under subsection 1, the land shall vest absolutely in the central government, free from all encumbrances.
So has this declaration been made under subsection 1 of 3D?
My Lord.
Which page is that?
This was page 69. Page 69. Notification dated 10/10/2018. In the second last para,
was the amount earmarked for the respondent deposited with Kala?
My Lord, if your Lordship will see page number 162, page number 162, we have the appellant herein had written another letter to the Kala dated 20/05/2024. At paragraph number 2, we have clearly stated that the respondent number 1 herein had already received an amount of rupees 8,75,516 as compensation towards his crops and trees, including 100% solatium, even though his land was not utilized for construction purpose.
Page 162.
162.
162.
Annexure number 8. Annexure number 8, page 62, second para. Lordship, during pendency of the petition before the learned single judge of this honorable court, we have intimated Kala that the land of the respondent number
when did Kala assess the compensation amount?
My Lord, this is also reflected in the same page, line number 2. However, Kala made assessment in respect of the petitioner's land white letter dated 29/11/2023.
That is only a communication. When did it make the assessment?
My Lord,
in 23.
Lordship, the 3G estimate is at page 81.
Huh?
81.
That's the original award.
Yes, this is the
where
original
the land
award.
value was not given. Then after
Yes.
the judgment of the single judge, assessments were made. That's
That
on
assessment
pursuant to the
copy,
judgment of the single judge, assessment was made by the Kala, which is at page 29 of my affidavit in the position.
Actually, you mean after single judge has passed an order for assessment?
yes, my lord.
Earlier in the original award, no land value was given, even though all other pata holders has been given land value. Then we filed
When were they given the compensation, the others?
on soon after passing of the award, Your Lordship, 7/3/2019.
They got the money.
They got
Only you did not get.
Only me, and we have submitted an RTI to the Kala saying why I'm not given an land value. And the Kala answered that it was a clerical error that I was not given land value. So the Kala said it's a clerical error only, I was not given land value. That is why, but since the Kala, we filed a representation, but since the Kala told us to go to the court, we went to the court and
Did you deposit money for him
My lord,
before Kala?
my lord, they have already received the compensation amount
Acha,
towards
they have already
crops.
received.
Yes, crops.
for the crops only.
From the damage of crops trees, including 100% solatium. And the assessed land value pursuant to the
So there
judgment of
was
the
no assessment of land value. You take back the land. You take the land. They have given you for crops. What more do you want?
My lord, if I may take your lordship to the judgment of the Supreme Court, because this is the issue here, your lordship, similar case, your lordship. In Chandrasekharan and another versus administrative officer and other 2012 Supreme Court cases 133. My lord, the appellants have not disputed that my land has been acquired. At para 25, I'll start from para 25, your lordship, page 146. Para 25, 26, 30, and 31, your lordship. If your lordship's got page 146. If I may kindly read, your lordship. At para 26, your lordship, it says that even if it is not used for the purpose, if it was so required. So land cannot, once vested under 3D, cannot be divested. And kindly, your lordships, at para 30 and 31, your lordship.
Now your land has been acquired under what provision?
National Highway Act. And there's another judgment, your lordship, similar case in Shimla, your lordship.
Yes.
Yes. In case of Sukhdev and others versus Union of India and others, 2022 SSC online, High Court of Himachal Pradesh at Shimla. Here the land, your lordship, here the land was acquired under the National Highway Act, same in this case, and it was proposed for making a tunnel. But thereafter they said that the land was not required for tunnel, and the National Highway people, they don't want to give the award. So it's the same similar case here, lordship.
They wanted to
They
return
don't,
the land.
they don't want to pay the award because they said we don't need it. So it
Para,
is
para.
start from para 3, your lordship, so that we understand the controversy. Para 3, kindly, your lordship. If I may kindly read the lordship. The limited grievance of the petitioners is that even after passing of the award dated 15/3/2021, the respondents have not released the compensation amount due and admissible to them. The only defense taken by the contesting respondents, National Highway Authority, in its reply is that the petitioner's land are situated over the tunnel falling beyond 6 meters. As such, the land in question is not required for creating any tunnel-related infrastructure or for the construction of the project highway. In the aforesaid circumstances, the deponent must humbly submit that since the land in question is not required for construction, the same may please be utilized by the landowners, and NHAI may please be divested from such land so as to have no right whatsoever in the land in question on account of the various notifications issued by the National Highway Act 1956. The landowner may please use the land in question as may be permissible under the law. Furthermore, in case such a land is required any time in future, same will be acquired as per the prescribed procedure as may be permissible at the relevant time. Paragraph 4. The gist of the stand taken by the respondent NHAI is that it had, though acquired petition's land in question, however, the aforesaid lands are now surplus and not required by it. The NHAI has prayed that it should be divested from the acquired land of the petitioners and landowners can utilize the land in the manner they deem proper. The stand taken by the respondent NHAI is completely divorced of the settled legal position. Regarding vesting and divesting of the land, acquired land in 2002, 8 SCC 129, Indoor Development Authority and Manohar Lal, this is a 5 judges bench, Your Lordship. It has held that once title vests in the state under Section 17 of the Land Acquisition Act 1894, divesting of the title is not a possibility at all. Once vesting takes place and it is with possession after which a person who remains in possession is only a trespasser, not in a rightful possession, and vesting contemplates absolute title possession in the state. And my Lord, if I may take Your Lordship to Parat 6. The petition's land have been acquired under the National Highway Act 1956, wherewith the provisions of the right to fair compensation and transparency in Land Acquisition Act 2013. Notification under Section 3A of the National Highway was issued on 2010-2020. Declaration of acquisition under Section 3D1 was made via notification issued on 11/12/2020. Section 3D2 states that on publication of declaration under Section 3D1, the land shall vest absolutely in the central government free from all encumbrances.
So there is a 3A application, 3A notification
Yes,
here also?
everything here.
My Lord,
so
even then, my Lord, the fact still remains that if Your Lordship will see the impugned order,
Just
a
a
direction,
minute.
yes.
Just a minute, it's not a fish market, one at a time.
So-
Actually, let him complete. Yes.
My Lord, the fact still remains that by the impugned order, the respondent number 4 herein, Kala, was directed to make assessment over the lands of the instant respondent number 1. However, in the impugned order, in the very first paragraph, it is reflected that even the Kala, respondent number 4, was not represented. So, my Lord, and
But you are not Kala.
yes. However,
Yeah.
direction was
Kala
given.
is here.
Yes.
Kala has not filed an appeal.
And we have also
They
intimated.
have accepted
yes.
the judgment.
We have also intimated our.
You have to fight
A
and you have to
letter-
stand on your own legs, Mr. Counsel.
My Lord, we have intimated to Kala that the land is no longer required as the.
How does it matter?
And my Lord, even then, thereafter, if Your Lordship will see at page number 164.
So your
Yes.
case is what? Your case is that though all the 3D notifications, everything was done,
Yes.
you did not need the land subsequently,
Yes.
which you communicated in 2023.
Yes.
Correct?
And, yes, my Lord.
And so the petitioners, the writ petitioner who has been given his compensation for the crops can now take back the land
My Lord. Yes.
without paying back the crop amount. Correct?
And also, my Lord, and also that our main grievance is that we should have been given a chance to file our objection, my Lord.
We are hearing you now, no?
Yes.
So
Prior to this.
all your objections, all your objections you put now. Any more objections besides that?
No, none, my Lord.
We are hearing you. That's your only objection.
Yes.
That once the land of the writ petitioner has not been touched,
Yes.
and you do not require it, he can take back his land without claiming any compensation for the land. That's your
Exactly,
case.
My lord.
Yes. that is
After
your
4
case.
years of taking up my land, which possession has been taken, Your Lordship, if I may take you to my affidavit in possession at page 27, Your Lordship. Not only did they take possession of, they acquire my land, they told me to get out of my land, Your Lordship, at page 27.
Actually, the land vests with them.
So possession was taken way back in 2019. Now 4 years later, they said we don't need it. And the Supreme Court has said that once you've taken over the land, you cannot divest it. It's 3D said it is vested completely to the central government.
Why don't you sell it in the market?
No. It's like,
You'll get a better price market instead of having it acquired.
if I may kindly be allowed, Your Lordship.
The land is vested or not? The land is vested, it will cover those portion.
No, because, okay. 3D notification has been issued. Now 3D says, on the publication of the declaration, the land shall vest absolutely.
That must have been explained.
Your Lordship, if I just give an example, supposing I buy a land from Mr. A. I took possession of his land, he gave me the LSC.
No,
it's in
no,
my name,
so,
then 4 years later I say I want to
so
give the
they
money.
have to give you compensation as per the market value,
Yes, Lord.
correct?
Correct.
So you have got already for the crops, you have got the money.
Yes.
You take the land, sell it in the market, you will get the market value. No, you.
After taking over my land, buying and changing
They want to
the
give you
LSC.
back. They want to give you back. See, they don't want to
My Lord, if once they are allowed to do this thing, if there's a precedence in this, then in every equation they will say that we don't need this later on. And
But if you are a businessman wanting money, I would say thank you, and now I'll sell it in the market for the market value. Otherwise, you're going to give me less than the market value.
my Lord, it kindly is like saying that I took possession of your land, I gave you some money, but 4 years later, I say I don't need your land anymore. Take it back and give me back my money.
So you see,
That cannot
the
go.
land value
Yes.
4 years earlier will be less than the land value now. You'll be making a profit. Basically, now since he was 3D notification has been issued. So the land
and-
vested. Now they don't want to use it, they want to give it back because they say that the road that was constructed does not touch the land of this person, that is petition. But Supreme Court does not say that one thing, this is this. You can't help it. And they will anyway given, for the crops they've already given money.
Yes.
Yes, that's all.
My lord, if your lordship could kindly come to page number 85 and 86. In fact, there was a joint verification team who had visited the
For what? To show
the
what?
place, and they have stated that
It does not touch.
yes, and that
How does it matter?
is no
We agree with you
Yes,
completely.
my lord.
There is nothing wrong. We do not doubt what you say. We
My lord.
know that's 100% correct.
My lord.
He also knows that it's 100% correct.
My lord.
Only thing he wants compensation.
Yes.
That's all.
That's
That's
all,
all.
my lord.
He agrees with you everything. But he says, as per 3D2,
Yes.
3D2 says that once a notification has been issued under 3.1, then under 3.2 the land vests absolutely
Yes.
with
the
the,
central
with the authority.
Yes.
Now once it lands, once it vests absolutely with authority, the decisions of the Supreme Court says that now you cannot divest it. It remains stuck with you for like a wife for good times and bad times.
Cannot go back.
Yes, in sickness or in health. So you do whatever, build a park or something. So what to do? Only you can put a fencing and set it off again. You'll get the same amount, market price. You'll get. Only thing you will not get that solatium. He'll get land value plus solatium, so he's thinking of that. Okay, right. Anything else? Kala, anything to say?
No, nothing to add, Your Lordship.
Acha, you were mentioning one page, 41, 42, something like that.
153 of the writ opinion. So
Regarding?
153.
Regarding
why I was not paid? Why I was not paid land value?
Oh.
153. You know.
You should make notes, small note, because so it becomes easier for us. One page you can just put date, page number, and tell us. Otherwise, now I've got to turn around here and there. Anyway, right. Heard Mr. T. Lal Zakima, learned counsel for the appellants. National Highways and Infrastructure Development Corporation Limited, bracket, in short, NHIDCL. Also heard Mr. Jonathan El Silo, learned counsel for the respondent number 1, bracket, writ petitioner. Full stop. Also heard Mr.
Jonathan Withdrawal.
Jonathan, are you also Jonathan?
Yes.
Jonathan Lal Withdrawal for?
Respondent 5.
Respondent 5, bracket,
Kala.
competent authority for land acquisition, bracket, Kala. And Ms.
Respondent number 2 to 4.
Caroline Lung Hoipui, K. Lung Hoipui, for respondents, for the state respondents number 2 to 4. Ms. Zaira Sangpui, CGC, appears for
Respondent numbers 7 and 8.
7 and 8. Huh?
6,
7 and 8.
7 and 8.
The present appeal has put to challenge the impugned order dated 16/11/2023, passed by the learned single judge in WPC 104/2023 on the ground that the writ petition had been disposed of without giving ample opportunity to the appellants to file an affidavit in opposition. Yes, sir. The next paragraph. The learned counsel for the appellants submits that the issue pertains to the claim for compensation for land value, the claim for land value compensation for acquisition of the land of the respondent number 1 for construction of a road under the National Highways Act, 1956, hereinafter referred to as the 1956 Act. He submits that even though a notification under section 3D, capital D, bracket 1 under the 1956 Act has been issued. And no, for acquisition of the writ petitioner's land, the road constructed by the appellants, which was completed on
My Lord, extension of time is 28/02/2023.
which was completed in February 23.
Yes.
Completed in February 23. Comma, did not touch or use any part of the writ petitioner's land. As such, there was no question of paying compensation to the writ petitioner, and the petitioner could take back his land. He also submits that compensation for crops and the consequential solution for the crops had been paid to the petitioner, writ petitioner, on
My Lord, date of receipt of the money is not reflected. However, the amount is given. In my letter to Kala at page number 162.
Intimation letter.
no, okay, don't say on full stop, on cut off, on cut off. Acha, that 3D notification was issued when? Atirakan, paragraph Tirakan, 3D notification.
10/10/2018.
Well, bracket one, no, was issued under the was issued on
10/10/2018.
2018, no? Comma, so continue. Okay. Next. That's all, I think, that's your case. What else? What is the other ground?
My Lord, that I should have been given opportunity of filing objection.
But we have heard you now.
Yes. But that was my ground.
Okay. The learned counsel's next para, the learned counsel for the appellants that submits that. The learned the impugned judgment and order should be the impugned order should be set aside, and the case remanded to the learned single judge, allowing the appellants to submit an affidavit in opposition prior to disposal of the writ petition. Mr. Jonathan L. Silo, the learned counsel for the writ petitioner, submits that ample opportunity had been given to the appellants to submit their affidavit. And as there was no dispute with regard to the fact that the land of the writ petitioner had been acquired in terms of the 1956 Act, and payments made for crops along with solatium, there was no requirement, there was no need for granting further time to the appellants to file an affidavit in a position on undisputed questions of fact. He submits that the question of returning back the land of the writ petitioner after it has been vested absolutely with the appellants in terms of Section 3D of the 1956 Act does not arise. As the NHIDCL cannot divest the land back to the writ petitioner in terms of the judgment of the Supreme Court, in terms of the judgments of the Supreme Court in the case of V. Chandrasekharan and another versus administrative officer and others, reported in 2012, 12 SCC 133. And in the case of Sukhdev and others versus Union of India and others, 2020, no, the Supreme Court in the judgment it is censored, and in terms of the judgment of the Himachal Pradesh High Court, in the case of Sukhdev and others versus Union of India and others, reported in 2022 SCC online HP 6425. A single bench judgment.
Your Lordship, one more judgment of the 5 judges bench of the Supreme Court.
Where is that?
It's Indoor Development Authority versus Manohar Lal and others.
Give us a copy. And in the case of the Supreme Court, 2012, Sukhdev Azokhanin, and in the case of Indoor Development Authority versus Manohar Lal and others, 2028 SCC 129. Oh, para, this one is para?
148 and 149, page 266.
Okay, anyway. That's all I think we have heard.
And one more point, Your Lordship. The Kala has given a reply to the RTI stating that it was only due to clerical error that land value was not given to me.
Okay.
While all other land quota holders have been given.
We'll just dictate you. The reason I'm dictating before you all is so that you can correct whatever we may have missed or made a mistake with. Okay. We have heard the learned counsels for the parties. Acha, wait. Then Mr. Jonathan learned counsel for respondent number 5 bracket Kala CLA submits that the payments for crops that the payments of compensation for crops to the landowners had been given by Kala on
The date has not been specifically mentioned.
Here also nothing given.
Lord, it was paid as per the 3G award, dated 7/3/2019.
When did you file your RTI application?
RTI application is in 8/5/2023. It's at page 151 of the writ appeal.
Can you, what have I said? Had been given on dash. The date will be filled up later. Given on dash. The reason for not paying the writ petitioner along with the other landholders was due to a clerical error, as has been reflected in the RTI reply made to the RTI question put to Kala by the writ petitioner, wide letter dated
22nd June 2023.
22nd
22nd June.
To 22/6/2023.
3.
Issued by, that is by him, no? Issued by.
SPIO, yeah, Kala. SPIO.
No, 22/6 was issued by whom?
State Public Information Officer.
Achha, issued by the SPIO. Kala Sership, no? That's all.
Your Lordship, if I may add, upon the judgment of the single bench, a fresh 3G estimate for the land value has also been made.
Full stop. He also submits that in terms of the impugned order dated 16/11/23, so you are challenging only the divesting. You are not challenging the judgment as such with regard to value of land to be added.
No, my lord. We have basically agreed that no opportunity was given.
Okay. What have I said? What did I say just now? Last para, last sentence. In terms of the impugned order dated 16/11/2023, passed by the learned single judge, Kala has now made an assessment of the compensation payable to the landowners for the value of the land. However, no payment has been made to the landowners for their land till date. Full stop. Acha, one more thing you write. Huh? The counsel for the appellant submits that the present appeal is not with regard to any challenge what has been made. What have I said? Made not with regard to any challenge on the direction of the learned single judge to the to Kala to make an appropriate assessment of the value of the land for compensation, as compensation. Correct? No. Why do you call? I didn't. थोड़ा बुलाएगा.
And Your Lordships, the reason we have not challenged the assessed amount of compensation is because this assessment was not intimated to NHIDCL. In fact, Your Lordship will see at page number 29 of the affidavit.
So this writ petition was filed because you did not get the compensation amount,
Land value amount.
the land value amount.
We were not intimated that the fresh assessment was made by Kala. That is why we have
What?
not challenged
Fresh
that.
assessment. Fresh assessment is as per this order. But then, okay, one thing is that won't they have a right to challenge whether you should be given land value or not?
My lord, it is because
You
they
see,
are,
it's not the issue of where the divesting, they cannot divest, that's all right. But whether land value should be given or not, that they should be allowed to challenge. We cannot put a roadblock to that.
if we see the prayer portion of
In?
the writ appeal, in the prayer, they say it is to set aside the impugn order. The impugn order give a direction to Kala to compute the land value compensation. So if they challenge this order, they automatically challenge the direction to the Kala to make the. So now they cannot say that we are not challenging the Kala's order. The single judge passed an order dated 16/11/2023, directing the Kala to make
I'm not
assessment. So that order has been challenged in this writ
No,
appeal.
you have asked for payment of the land value.
Land value, compensation, yes.
They are saying that we don't want the land, so it should go back to him. Now the single judge has said that they have to pay the cost, correct? They have to pay the cost, they have to pay the land value. They have to pay the land value. Now, the question of whether they have to pay the land value or not is a different issue. With regard to their first point, that is gone. They cannot divest. So now, why did the learned single judge say that Kala should assess the land value?
My lord,
What was the
we
ground?
challenged the original award passed by the Kala where we were left out land value. And
Others were given land value.
others were given. Only me was not given.
Okay.
So we challenged the award.
Others were given land value.
Others, everyone has been. Only me was left out. And
Others were given land value on what basis?
because they were holders of P-Pata.
No. When were they given on what basis? They were holders of P-Pata.
Yes.
But in the award,
Yes.
their names are not, they were not given land value, correct?
They were given land value in the award.
Achha, you were not given land
Only
value.
me was not given land value.
In the award?
Yes. And
You were given compensation for crops only. In the
only.
award. Let us see the award.
My lord, in my affidavit in the position, your lordship, page 25. This is the extracted relevant portion. Page 25, your lordship, annexure 8.
Page 25.
25, annexure 8. 3G estimate for acquisition, your lordship.
Yes.
Yes. And if we turn to, this is the award. Where's the complete? If we turn to the next page, your lordship, second from last 132. My pata number is 62 of 2004. And if we go to the column number 8, land value, your lordship, so 0.
Okay.
And my lord, if you just take note of the person above me, 131, Al Soma, your lordship, just person above.
Yes.
He is also holder of P-Pata. He is my neighboring land. He has been given land value at column number 8.
But you have been given compensation for the crops.
Only crops. Because of the clerical error.
What we'll do is, no time now. You just give us a list of dates. Tomorrow we'll take it up, we'll dispose it of tomorrow. Okay? Just list of dates with these pages. Let's make a small synopsis.
Yes, yes.
Okay?
Your Lordship was asking the question, why was the learned single judge directing the respondent number 4 to make assessment?
Yes.
This is reflected at para number 6 of the impugned order. Para number 6 of the impugned order, this is at page number 4.
Yes.
If I may read. Accordingly, the writ petition is disposed of with the direction to the respondent number 4 to make appropriate assessment for the value of the land of the petitioner which was affected due to construction work, along with all other statutory benefits. Now, the reason why assessment was directed was that the petitioner's land which was affected. Now,
Okay.
in the instant case, the land of the petitioner was
Not affected.
not affected at all.
This is not good for you, this portion.
So, my lord, that this,
Because
in
it
the
says that
agreement,
which
we
was
have
affected.
submitted.
But his land is not affected. Okay. It cannot be divested, but he has also to put a challenge to this order.
My lord, my land, if I may take you to, if I go to the writ petition, if we go to writ petition, we have said that my land has been acquired.
No, you see, let us see the wording. Let's see the wording. It says here, accordingly, the writ petition is disposed of with a direction to the respondent number 4 to make an appropriate assessment for the value of the land of the petitioner, which was affected due to the construction work.
Yes, my lord. My lord, at the time of filing of the writ petition, my lord, if we go to the writ petition, we have clearly stated that we have annexed the art.
Or can we say that because it was required for the purpose? Can we say that?
My lord, if I may kindly take you to page 82 of the writ appeal.
No, we get it. That word should not have been there. Which was affected due to, could have said just which was affected. It's enough. Due to cost. Which was acquired for the purpose. That's all.
It was acquired for the purpose.
That is not the word used.
At that point of time, my lord, that is why that it is our stand that my land is affected, your lordship. We have not.
Anyway, you give a small synopsis. Tomorrow we'll take it up. Okay. Hello, time, bro. Acha, before that, I'll give you some more dictation later on.
My lord, those two items, those central YMA items, if it can be taken up tomorrow, my lord. Documents, they have not found all the documents yet. So,
Okay,
may
tomorrow.
take some time.
Item number?
Supplementary items 7 and 8.
7 and 8. Mrs. Linda L. Fambor, additional AG submits that. Only how many land
Six.
passes?
Six
Submits
of
that 6 land passes are still to be traced out.
Yes.
She accordingly please that the matter be listed tomorrow. List the matter tomorrow.
Oblige.
See, when you get down to it, this matter has been pending from 2020.
Yes.
And suddenly within 2 days we have found everything. Nearly everything. Yes, sir.
For admission.
Yes.
Item number 9.
Yes.
Lordship, this is the letter from the Registrar, Administration, Gaudi High Court, Principal Seat to the Registrar, Aizawl Bench, when he has intimated him regarding the decision of the High Court to accept the proposal for exchange.
Okay, what have I said? Last, in this item 9, which in Ahan Kha, Annexure X and Y. Okay, sit down. Next, continue, huh? This item 9, we just say. We have also been, Mr. A.R. Malhotra, learned counsel for the, Standing Counsel for the High Court has submitted a letter dated 27/11/25 issued by the Registrar bracket Admin, Guwahati High Court, addressed to the Registrar, Guwahati High Court, Aizawl Bench, stating that the Guwahati High Court has been pleased to accept the proposal for exchange of the existing district court building at Lunglei with the land and building of the printing and stationery department, Lunglei. First up. Next para. The learned additional AG shall obtain instructions with regard to the same.
Your Worship, if I may, as per the letter marked Y, the Undersecretary JAD has requested the District Judge Lunglei to approach the Deputy Commissioner and Chairman. The District and Session Judge had approached the Honorable Chief Minister directly. So now they have requested the District Judge to approach through the Deputy Commissioner Lunglei.
What have I said? The above being ceremony. What's the last sentence? The learned? No, cut that. They say, in view of the contents of Annexure Y, the District and Session Judge Lunglei, Judicial District, shall immediately
If Your Lordship will see the letters which I just handed over to Your Lordship at page 3, the Lunglei District and Session Judge had written directly to the Honorable Chief Minister. That is letter dated 4th of December 2025.
No.
So now the GAD Undersecretary has requested the District and Session Judge Lunglei to approach the Deputy Commissioner first.
In view of Annexure Y, Judge Lunglei shall immediately send the proposal for exchange of the land at Lunglei to the Deputy Commissioner and Chairman District Level Government Land Authority Lunglei with copies to the Registrar of the Guwahati High Court and the Secretary to the Government of Mizoram, GAD Department. GAD.
And Your Worship, as well as to the MBA, so that we can also pursue the matter with the...
A copy of the said proposal should also be submitted to the Mizoram Bar Association. Lunglei sub-headquarters. To the President of the Mizoram Bar Association, Lunglei sub-headquarters. This is the matter. No, full stop. Thereafter, the Deputy Commissioner Lunglei and the Registrar, Deputy Commissioner Lunglei and the GAD, Mizoram shall take necessary steps regarding the proposal for exchange of the existing, regarding the proposal for exchange of land for the district judiciary at Lunglei. This is the matter. When? Short date.
2 weeks, my lord.
Give after 2 weeks a date. You pursue the matter also?
Yes, my lord. 11 February. For hearing, item 11. Item 12.
These lordships. Lordships, this is an appeal against the judgment of the single bench lordship, dated 18/10/24, wherein, my lord, the MRB was directed to refund the forfeited amount of 5,79,376 to the respondent, my lord, holding that that amount was originally derived from provident fund, my lord, which was stated to be immune from forfeiture in view of the protection given by Section 10 of the Provident Fund Act 1952, Lordship.
Let us see this Section 10 of the
10,
Provident
Lordship.
Fund
Yes.
Act.
If I may read, Lordship.
Yes.
The protection given in the Section 10 of the Provident Fund Act, Lordship, is the amount standing to the credit of any member in the fund. Any member in the fund. What is the fund, Lordship? Definition is there, my lord. Fund means the fund established under the scheme. What is the scheme, my lord? Scheme is the Provident Fund scheme, my lordship, which was looked after by the Provident Fund organization, my lordship. So, in simple meaning also, my lord, the fund herein means fund is a collection of different people's money, my lord. A fund is different people's money put together, my lord, in a scheme for a specific purpose. For example, my lord, we may also have investment fund, mutual fund, all these are fund, my lord. The moment it has been taken out from that pool of money, my lord, it no longer is fund.
It loses the protection of Section 10.
Protection ends there, my lord. Protection ends the moment it is taken out from that fund, my lord.
So this money was forfeited from where?
From his savings
account.
Normal savings account, lordship.
From
the moment
bank?
that, yes. So
Protected from attachment by any decree or order of any court. to be covered. Because it's not a court. Oh, yeah, I think.
Yes, carry on.
So, my lord, the language of section 10 itself is very clear, my lord, very clear. The amount.
So out here the case was that he was accused of embezzlement of how much?
My lord,
money?
my lord.
How much?
Altogether about 18 lakhs, if I may take lordship to the.
Let us see the charge.
The order in the criminal order, trial, my lord.
Page.
Criminal order, page, it begins from page 52, my lord. 52, onwards. And herein at page, towards the end of that judgment, my lord, if I may take lordship to page 69, your lordship.
Yes.
69 of the appeal, your lordship. Here, in the around the middle of the first paragraph, your lordship, there is figures that stated that the case IO stated that during his investigation, he found rupees 18,90,000 was misappropriated by the accused. So, my lord, in this case, my lord, the late husband of the present respondent was convicted, my lord, through the period he had already undergone, my lord. And he, my lord, also, it is stated herein in the next paragraph, my lord, that the accused himself in his cross-examination under 313 of CRPC stated that his GPF amounting to 5,666 were forfeited by the bank. His area of pay, a little over 1 lakh, was withheld by the bank. And he also surrendered his suspense allowance amounting to 50,000 to the bank. In all, the amount of 7,18,000 were surrendered by him to the bank. Therefore, the accused, P.C. Nunmoy, also held himself responsible for the detected discrepancies of the cash in the bank. So actually, my lord, he himself admitted that he was guilty, my lord. So there was no challenge to this conviction order also, my lord. Thereafter, he also surrendered some of the misappropriated amount also, amounting to more than 7 lakhs also. So apart from that now, the present amount which is in dispute today, my lord, 5 lakhs and 79,376, which originally was derived from his provident fund, my lord, held to his credit, my lord, was released to him, my lord, and that was credited into his normal savings bank account in his MRB account, my lord. So that, my lord, no longer is a part of the provident fund. So there is no protection that is extended there to, my lord. The protection given in section 10 is only, and as far as it is part of the fund. Part of the fund, my lord. So the language itself is very clear, my lord. So I think that is the sum and substance, actually, my lord.
And the DP, let us see the departmental proceeding.
My lord, yes.
The order, page.
Page 71 onwards, my lord.
Cannot read also 71. How do you read? How does the registry allow this type of pages? I can't read. Can you read? Yes, this is unreadable. Why don't you give better copies?
Oh, my lord. But my page is readable, my lord.
Oh, then you come and sit here, I'll come there. Yeah, I've got to write the judgment. I've got
Apologies,
to
Your
write the
Lordship.
judgment.
Apologies, Your Lordship. I am not aware that that one is not eligible, Your Lordship. And page number may also, my lord, be different. Maybe. Then
No, which is the page you are talking about? Page 70,
here in my lord,
71?
71 is order. Is it similar with your
No,
lordship's copy?
71 is not order. Annexure 3.
Annexure, no, Annexure 2, my lord. Annexure 2.
Annexure 2 is page 70.
Sorry. So this is the order given out, this is the dismissal order, Lordship.
Where is the charge framed against him? Where is the inquiry report? What was the charge framed against him?
Regarding the charge, my lord, I think that is not part of the record herein, my lord.
There has to be.
Since that, my lord, actually was not in dispute, my lord.
No. We want to
That
know
is
what is the charge.
mine.
Was he accused of stealing a banana, 2 bananas, 1 lakh, 20 lakhs? Where is that? There's nothing here.
The charge regarding that, my lord, is...
Look,
well,
your
hearing
entire
that.
case is basically to the effect that he has embezzled or misappropriated money. Correct? How much is that money in the DP? Is the money amount in the DP and the criminal case the same? We do not know. So these things you should have given us. Anyway, so that is your basic case.
My lord, actually, yes.
You bring the charge tomorrow. Anyway, yes, Mr. Ramza. Any citations, by the way?
Actually, my citation regarding delay, my lord. On this part of this section, no, my lord. I have no citation.
Delay?
Delay, yes.
He filed his writ petition.
In filing writ petition 18 years later, my lord.
18 years later.
Lapse of 18 years, Your Lordship. And that delay, my lord, was not explained anywhere in the averment made in the writ petition, Your Lordship.
Where is the writ petition?
It starts from page 31, Your Lordship.
31 to?
31 and 31 to all these are annexes in the writ petition, Your Lordship. The next pages till page 93, Lordship. No, my lord. 85, sorry. 31 to 85.
No, 31 to 50.
Yes, that is the averment, my lord. Yes.
Huh?
Writ petition.
The next pages, Lordship, are enclosures,
No, you
annexes.
see, Mr. Counsel, the explanation of the delay can only be in the averments made in the writ petition, not in the annexures.
Averment starts from page 41, my lord. And one averment, Lordship, which is close to explanation is paragraph number 11. But actually is not justifying the delay of 18 years. But actually, there is talking about pandemic. That pandemic was only lately.
Yes.
So actually, he was dismissed from service way back in 2005, my lord. 2005 March. Pandemic only happens in 2020, lords.
That's all.
Regarding that, my lord, I have citations, if I may be allowed to place.
Yes.
2000, volume 6.
Yes.
562, Your Lordship.
SEC.
Yes.
Paragraph
number 6, Your Lordship.
6, yes.
Herein, if I may be allowed to read, Lordship.
Yes, yes.
The order terminating the services of respondent was passed on so-and-so. The writ petition was filed challenging the said order and so-and-so almost after a period of 6 years. There was no explanation in the writ petition whatsoever for this inordinate delay. The respondent sought for his re-employment in the corporation by his letter dated so-and-so, almost after a period of 5 years from the date of termination of his services. It only indicated that he accepted the order of termination of his services, if not expressly but impliedly. In the writ petition, no ground was raised as to the privation of right of appeal to the respondent against the order of the termination of his services. It is not the case of the respondent that he was denied any opportunity offending principles of natural justice. An inquiry was held pursuant to the charge sheet. Witnesses were examined, and even the respondent examined 3 witnesses in his behalf. The inquiry officer, looking to the evidence brought on record, found the respondent guilty of the charges. It was also not shown in any prejudice was caused to him in the inquiry. The disciplinary authority, concurring with the findings recorded by the inquiry officer, after giving further opportunity to respondent, passed the order terminating the services of the respondent. This being the facts and circumstances of the case, in our opinion, the land judge was right in dismissing the writ petition. So actually, 6 years was also regarded as too much here in this case, my lord. And if I may be allowed to rely on another citation, 2021, 13.
2021?
13 SEC.
SEC?
225.
22.
Paragraph 11. 225. 225.
Yes.
Paragraph 11, Lord.
Yes.
While it is true that limitation does not strictly apply to proceedings under Articles 32 or 226 of the Constitution, nevertheless, such rights cannot be enforced after an unreasonable lapse of time. Consideration of unexplained delays and inordinate lapses would always be relevant in writ actions, and the writ courts naturally ought to be reluctant in exercising their discretionary jurisdiction to protect those who have slept over wrongs and allow illegalities to fester.
Next. That's all?
Actually, my lord, they actually have not challenged the order which is directing the deduction, my lord, the forfeiture.
Where is the order directing deduction?
Page number 74 in my copy, lordship. Order.
Well, this is your writ petition. I hope we are on the same page.
Actually, my lord, there might be some discrepancies.
Okay.
74?
74 to 75, lordship. Order. Embezzlement of fund by.
Okay. Page 74.
74 to 75, lordship.
Exercise of powers.
I think if I may be allowed to read through, my lord, from the second paragraph, my lord.
Yes.
In the said circumstances, it is essential on my part to make recovery for all losses caused by you to be recovered from you. While the aforesaid dismissal order was passed, you had no money in the bank to effect recovery, whereby the bank could not recover its losses caused by you for an amount of rupees so and so and so. Now,
you see, this is where, now you see, in your criminal case,
yes,
you said that the misappropriation was 18 lakhs.
Yes, Lordship.
Now out here,
it's 9.
It's 9. That is why we wanted to know the difference. How come you've got 2 different figures? Anyway, that's not an issue, but we want to know the right figure. How much has been misappropriated? Your your shaking of the head hasn't helped. It has not answered. It's like saying, no, yes, it's like saying yes. You've got to tell us. Criminal case says 19 lakhs.
Regarding
Out
this
there
issue,
it is 9 lakhs.
My lord, I'll obtain instruction and inform lordship tomorrow if possible. Then now we have an amount of so and so. That is the
We have filed a civil suit.
civil suit for withdrawal, my lord. But since that upon receiving instruction was not necessary, so it was later withdrawn, my lord.
Real clause, okay. Chairman,
So this is in continuation, my lord. Continuation of the earlier dismissal order, my lord. Now, in exercise of power, as chairman of the MRB, the discipline authority of MRB, regulation so and so, and also in exercise of the power conferred in section 21 of the General Clauses Act 1897, I add herewith in the original order of dismissal that the loss caused by you to MRB for an amount of so and so, which your amount of rupees 5,79,376, which is available with our Aizawl branch in the account number saving bank 4813, standing in your name is hereby forfeited, and the said amount of so and so is taken out in order to recover the loss caused by you to MRB. This lordship order has also not been challenged. So, actually, they come before your lordship without challenging all these original orders, madam.
You clarify 18 lakhs and
18
9
and
lakhs.
9.
You bring the charge sheet,
Madam.
bring the records. Okay, that's one. But we get any other thing, any other point?
For that, my lord, since they have not challenged, I have citation.
Okay.
(1995) Volume 6 SCC 749.
Yes.
749.
Para?
18.
Yes. The disciplinary authority and appeal the appellate authority, being fact-finding authorities.
Yes, lordship. A review of the above legal position would establish that the disciplinary authority and on appeal, the appellate authority, that is the statutory appellate authority within the bank manner, that they have also not preferred statutory appeal also, my lord. Being fact-finding authorities have exclusive power to consider evidence with a view to maintain discipline. They are invested with the discretion to impose appropriate punishment, keeping in view the magnitude, gravity of the misconduct. High Court Tribunal, while exercising the power of judicial review, cannot normally substitute its own conclusion on penalty and impose some other penalty. If the punishment imposed by the disciplinary authority or the appellate authority shocks the conscience of the High Court Tribunal, it would appropriately move the relief, either directing the disciplinary authority, appellate authority to reconsider the penalty imposed or to shorten the litigation it may itself, in exceptional and rare cases, impose. So, this, my lord, if the penalty imposed on the respondent is found not appropriate or shocking to the conscience of the court.
That is a different issue, Mr. Counsel. That is not under challenge.
Yeah,
He's
that
only
is why, my lord,
challenging, he's
they
only challenging the forfeiture of the amount. He's not challenging the punishment.
Exactly, my lord. That is why they have not challenged.
You see,
by circumventing, my lord,
this,
they cannot challenge the
money that has been embezzled. It doesn't mean that just if you order recovery doesn't mean that that is a penalty. That is a natural consequence of the misappropriation, the misconduct.
Exactly,
it has to be given back. It's not a question of penalty out there.
That's all, my lord. That's some sense of some my lord.
Yes.
Lordship, After hearing the clarifications, I may be allowed to make my submissions tomorrow.
There's no clarification. Only clarification required is with regard to 19 and 9, 18 and 9. The others is all, that the other issues are all with regard to law points. The only issue is, why can't the bank make recovery of the loss they have suffered due to misappropriation, which has been proved?
Yes. So
It's
far
like-
as that
it's
is
like
concerned,
saying- it's like saying-
in the earlier proceeding of this Honorable Court,
Yes.
the issue that has been specifically framed
Yes.
is that having heard at length the submissions made by the land councils, the senior counsel submits that he may be given time to produce some authorities in support of his point that the money from Provident Fund deposited into the savings account of the respondent can still be considered as Provident Fund under Section 10 of the Employees Provident Funds and Miscellaneous Provisions Act 1952.
Correct.
The
more
money,
than a month has been
the money
given.
which was kept as such, the moment it is released, whether it is still immune from attachment. That is the issue that needs to be decided by the Honorable Court.
Correct. Yes, sir.
And the only authority which is now under challenge is that this is the money which has been kept as a provident fund, and it continues to be.
Which was part of the Provident Fund.
No, it is a provident fund which was released to the petitioner, to the writ petitioner in his account.
Correct.
The moment it is released to the petitioner's account, it ceases to be the provident fund.
Correct.
That is the interpretation made by the bank. But the view that has been adopted and held by the Provident Fund authorities is something different. And also we'll see from page 78, this is a letter from Employees Provident Fund Organization, Ministry of Labour, Government of India, Ministry of Office of Assistant PF Commissioner, addressed to the Chairman, Mizoram Rural Bank.
Page 78.
Page 78. Lordship, whether it tallies.
Yes.
By this letter, this on the subject of forfeiture, attachment of Provident Fund money in respect of Zonghming Thanga, holding account number so-and-so, and P. Silal Nun Moya, holding PF account number AS 1671/23. May I read the Lordships?
Yes.
With reference to the subject cited above, then the sign has received representation from Zonghming Thanga and P. Silal Nun Moya. We are now concerned with P. Silal Nun Moyas, informing that the Provident Fund money is for rupees 4,58,098, settled white check number and so.
Where are you reading?
I'm reading first paragraph.
It starts with, we have never attached.
No.
Letter dated 21/11/2006.
That I'm reading the letter from the Assistant Provident Fund Commissioner addressed to the Chairman.
Okay, that is at page 80.
6A.
That's page 80. Page 80.
80.
Yes, 15/12/2006. That's not 78. Yes, please tell us.
Here, with reference to the subject cited above, then the sign has received representation from so-and-so, informing that it's Annexure 6A.
6A?
6A.
Page
78. Here in my.
What is the letter dated?
It's a letter. The date is not given here. It's a true type copy.
We don't have any typed copy.
It is
Annexure 6. The true type copy is Annexure
This is the
6A.
Annexure 6. Page 76. How come you're giving such bad copies?
That version is that copy.
Huh? 77.
Forfeiture. I think there is a-
This is the one. Okay, please read. Page 70. Please read.
I'll just go to the second para. In connection with the representation,
Okay.
as stated
Page
above.
77. That's page 77.
77.
Yes.
As stated above, it is to draw your kind attention to the provisions laid down under Section 10 of the Employees Provident Fund and Miscellaneous Provisions, Act 1952, and Section 60, Subclause 1, Subclause K of the CPC of 1908, wherein it has been clearly written that all compulsory deposits and other sums in any fund or derived from any fund to which the Employees Provident Fund Act 1952 for the time being applies shall not be liable to attachment insofar as they are declared by the Act not to be liable for attachment. These provisions clearly show that Provident Fund money or any sum derived from Provident Fund are immune to forfeiture or attachment. In view of this, the undersigned is constrained to direct you to refund the Provident Fund money in respect of Zonghing Thangay and PC Lanun Moya illegally forfeited by your office to the respective Provident Fund beneficiaries forthwith. A line of confirmation in this regard should be communicated to the undersigned within 7 days of receipt of this letter. Lordship, this authority, that is the Employees Provident Fund Organization, Assistant PF Commissioner, he has clearly stated that these provisions, which he has quoted here, that is Section 10 of the EPF, Miscellaneous Provisions, Act 1952, read with Section 61K of the CPC, would clearly indicate that they are immune from attachment. And not only the Provident Fund, as they are in the custody of the PF Commissioner, but also any sum derived from Provident Fund. So once it is released from the Provident Fund account, it continues to be immune because it is a sum derived from the Provident Fund. So that is the interpretation and
you see, but then it says here, the amount standing to the credit of any member in the fund.
Yes.
It has to be in the credit in the fund.
That is true.
So once it leaves that fund and it goes to a private member's account, it ceases to be in the fund as defined in this Act.
Decree order of a court.
Plus, if you look at Section 10, it says that shall not be in any way be capable of being assigned or charged and shall not be liable to attachment under any decree or order of any court. Now, where is the decree or order of the court?
There is no decree. There is no order of the court. It is only the order of the disciplinary authority. It is only the order of the disciplinary authority that he is to...
He's not barred. Under Section 10, he's not barred.
Your Lordship, this interpretation has been made by the learned single judge. The learned single judge had rightly come to the conclusion. Your Lordship, if I take Lordship to the judgment.
Yes.
At page 6 of the judgment, if I read from para 9, May I read from para 9?
Yes, yes.
From the above abstract, it may be seen that the amount standing to the credit of any member of the fund is not liable to be attached.
No, you see, that is the thing.
Yes.
I think the mistake lies in any member of the fund. It should be any member in the fund.
Component of the fund.
Yes, it has to be a component of the fund.
Yes, any member in the fund.
It should be in the fund. That
Yes,
is where I
yes.
think a mistake might have occurred.
That does not make a substantial difference here also.
Oh, it makes a huge difference. That is
And here,
that is what the statute provides. You see, the statute says in the fund.
Yes, yes.
Now, when you say
It may
of
be
the fund,
seen that the
of
amount
the
standing
fund,
to the credit of any member, even if it is read as in the fund,
yes,
is not liable to be attached.
yes. So, in the
under-
fund means in which fund? Now, that fund definition is given in the Act, in
any
section
decree
2.
or order of any court in respect of any debt or liability incurred by the member. In the instant case, the impugned order provides that the amount that was forfeited is for the purpose of recovering the loss caused by the late husband of the petitioner to the Mizoram Rural Bank. It may further be seen that as per section 61K of CPC, it is provided that all compulsory deposits and other sums in or derived from any fund to which the Provident Funds Act for the time being applies, insofar as they are declared by the said Act, is not liable to be attached. Similarly, Regulation 45.4 of the Regulation of 2010 also does not permit.
This is also whether it can be correct. It may further be seen that as per section 61K of the CPC, it is provided that all compulsory deposits and other sums in or derived from any fund. Let us see the CPC.
All compulsory deposits section 61K.
Correct. There's no problem. You see.
From the fund.
So it says all compulsory for the time being, insofar as all compulsory and other sums from any fund to which the Provident Funds Act applies. So his account will not, your account will not be applicable, will not be covered by the Provident Funds Act.
Lordship, whether the money is more important than the account, because it is the money which is sure to be attached.
You see, it's not the question of the money or the account which is more important. The statute requires the protection of a provident fund so long as it is in the provident fund account.
Right.
That is the only protection guaranteed. Once it leaves the provident fund account, it may be your provident fund, but your provident fund, once it leaves the provident fund account, then that protection goes. Once it comes into a different account, which is not covered by the Provident Fund Act, then the protection goes.
This is how the bank makes its interpretation, but not the Provident Fund authorities. Lordship, may I continue to read the impugned judgment?
Yes, sure.
How he has come to the conclusion. Similarly, Regulation 45, subclause 4 of Regulation of 2010 also does not permit holding back of an amount which is contributed to contributory provident fund. Therefore, having regard to the protection as contained in the aforesaid provisions, it only appears that the amount which was forfeited from the Provident Fund money to be received by the petitioner's late husband has been wrongly forfeited. The case of B.C. Chaturvedi, supra relied upon by the learned counsel for the respondent number 1 and 2, is in respect of modification of penalty imposed by the delinquent officer. According to the Apex Court, even if such a penalty is to be modified, the same should be referred back to the disciplinary authority for imposition of appropriate punishment. The same, however, in the considered view of this court, will not be applicable to the instant case, since the very forfeiture of the Provident Fund money is not permissible in law. Although the learned counsel for the respondents number 1 and 2 has mentioned that once the amount is credited to the account of the petitioner's late husband, the same loses its color of its source. The same, in the considered view of this court, cannot be accepted. More particularly, when there is a specific reference to that the amount was credited in the account of the petitioner's late husband, white check number so-and-so, amounting to rupees 5,79,376 only, which exactly is the amount which has been forfeited from the account of the petitioner's late husband by the impugned order dated 9/10/2006. Therefore, the contention made by the learned counsel for the respondent number 1 and 2 cannot be accepted. This is the view held by this honorable court in single bench.
This order has specifically stated that the money has left the Provident Fund account. White check number so-and-so amounting to rupees so-and-so and credited into the account of the petitioner's late husband.
Right.
So it has left the protection of this section 10.
That is true.
It doesn't remain.
It is.
In your bank account, I don't think you differentiate that out of maybe 1 crore or 2 crores or 20 crores that you have, 100 rupees is from so and so, that 1 lakh is from so and so, 1 lakh is from another.
And it is exactly the same amount.
That loses its
It is
color.
exactly the same amount that has been credited to his bank account, which has been forfeited. And
but you see the thing. The single judge has clearly held
as long
that,
as
the amount has left the security of the fund provided in the Provident Funds Act.
As long as it is in the Provident Fund account, no one can touch.
Correct.
No one can
So
touch.
long
Even
as-
the petitioner cannot
correct.
use.
We agree.
Even
Totally,
the petitioner cannot
100% we agree.
What will be the use of keeping that
The thing is that it has left
in
the
the safe
security.
custody of the Provident Fund
Mr.
authorities?
Counsel, you are not, that's what you are arguing our case now. I mean his case. You are arguing his case because the single judge has clearly stated that this Provident Fund amount of rupees 5 lakhs has been credited into your account
That's true.
by check number so and so. That means it has left the security of the fund, the protected fund, which is defined in section 2H. Section 2H.
Fund means, Your Lordship, the Provident Fund as establishment under a scheme.
Correct. Your savings bank account is not a fund.
Fund means
Under the
fund
Provident
means-
Fund scheme. Only the money was under that fund,
Yes.
but the money has left. Once it leaves the security, it's gone, finished.
It is the money contributed by the
Maybe.
petitioner and kept in the Provident Fund account. Now, this is the money which in which we are interested.
Once I retire as a High Court judge, I am no longer a sitting High Court judge. I'll be a retired High Court judge. So your money was Provident Fund money under the fund protected by the Provident Funds Act. Yes. Once it has left that fund and gone into an account, any other person's account, then it is no longer, your account is not a fund under the Provident Funds Act. That security is lost.
That is one way
And
of looking at it.
another thing, there's another thing. Section 10 provides protection only against the orders passed by a court.
The court cannot attach. That's the court order.
Yes,
By
only
decree and order.
court cannot attach, that's all. It's like, you see, it's like this. A person steals 1 crore. He is found guilty by the criminal court. He is found guilty in the departmental proceeding. You mean to say that they cannot take back what he has stolen as long as they find the money? That is a very wrong way of looking at things. Okay, he has stolen so and so, let him carry on enjoying it. Cannot be done.
Your Lordship, this interpretation, which is in favor of the interpretation made by the learned single judge, is also made by the authorities of the
We do not
Provident
agree.
Fund.
Unfortunately,
And
we do not agree.
Your Lordship, the moment, supposing, for example, the money, it is released today. The moment it is released, if it is attached, and if it is forfeited, the moment it is just put into my bank account, if it is forfeited, what is the purpose of keeping it immune while it is in the Provident Fund account?
You ask the persons who made this law. We don't know.
Because
we don't know. We are just following the statute.
I'm trying to reason out.
Unless you make a challenge to this provision, section 10, unless you make a challenge, that argument is of no use. It's just of academic interest. We can neither set it aside or take a different view. That, though we might say 1,000 things, but the statute still remains unless you make a challenge to the statute.
So, in that view of the matter,
yes,
that's it.
We have got no choice. I mean, we have got our views. You have got another remedy. You can always go to a higher court and place your grievance there if you find that we are wrong. And we might be wrong also. We don't know. Right. Heard. Ms. C. Zoram Chara, learned counsel for the appellants. Also heard Mr. C. Lal Ramzawa, learned senior counsel, assisted by Mr. C. Vanal Botsaya. Stephen Anand Botsaya. The appellants have put to challenge the impugned order dated 18/10/2024, passed by the learned single judge in WPC 116 of 2023. Wherein the learned single judge had directed the appellants to refund the forfeited amount of rupees 5,79,376 to the respondent within a period of 2 months from the date of the impugned judgment and order. The issue relates to whether Section 10. No, the issue relates to whether the forfeiture of the above said amount from the savings bank account of the respondent by the appellant is hit by Section 10 of the Employees Provident Funds and Miscellaneous Provisions Act, 1952, hereinafter referred to as the 1952 Act. The brief facts of the case is that the respondent had misappropriated money from the appellants while working in the Mizoram Rural Bank. The departmental proceeding that had been initiated against the petitioner, against the respondent, found him guilty of having misappropriated money and vide the impugned and vide order dated 30/3/2025. The respondent was dismissed with immediate effect. Have I given the order date? Order dated 30/3/2025. I said already, no? Okay. Dismissed with immediate effect. On account of embezzling a large sum of money by manipulating accounts and fabricating false documents.
Lordship, it will be 2005.
2005, 2005, huh? Next. A criminal proceeding had also been initiated against the respondent, which started with the registration of share sheet PS case number 75/2000 dated 14/8/2000 under section 409/465/471 IPC. After submission of charge sheet, trial was conducted by the Court of the Additional Sessions Judge Aizol in criminal trial number 1536/2000. The criminal trial culminated with a judgment and order dated 29/12/2009, passed by the learned Additional Sessions Judge Aizol, wherein Mr. Counsel, your page 69 and 70, how is it joined? Oh, this is different. The criminal case. Your criminal case ends where?
70, Lordship.
How can it be 70? 70 is by chairman and disciplinary authority.
Sentence. Till here it is criminal case.
What kind of petition are you submitting?
In my copy, Lordship.
In your copy, that's the problem. You have got a separate copy. We are supposed to be on the same page.
Convicted on. convicted on 409, 465.
Okay, what have I said? That the completed with the judgment and order dated 29/12/2009. Huh.
Conviction.
Passed by the Additional Sessions Judge 1, Aizol, convicting the appellant, the respondent, under Section 409/465 IPC.
Oh, yeah, it's different. We did already.
And sentencing him to undergo the period of imprisonment, or what? Period of imprisonment as an under trial prisoner, already undergone by him. Full stop. No appeal has been filed by the respondent against the dismissal of the petition on the basis of the departmental proceeding which concluded by order dated 30/03/2005, and the and his conviction in the criminal case by judgment and order dated 29/12/2009. Subsequent to the above, no, wait, then the judgment. Acha, where is that the amount that he has given back? Acha, here.
Forfeiture.
The judgment and order dated 29/12/2009 passed by the learned Additional Sessions Judge -1 Aizol in Criminal Trial 1536/2000 has recorded the following. Page 69, huh? In red, okay? In red. The impugned, no, the above being said, the subsequent to the above events, the respondent filed WPC number 116/2023 on, when did he file? When did he file the petition?
I mark it in my copy, my lord.
Give it back.
He filed it on 26 September 2023.
26/9/2023. Praying for a direction to be issued to the respondent, to the appellants, as to why order number G-24/558 dated 9/10/2006, passed by the chairman, Mizoram Rural Bank, should not be declared as null and void. The further prayer of the respondent was that a direction should be issued to the appellants for payment of the Provident Fund amounting to rupees 5,79,376 with interest. Full stop. The order number G-24558 dated 9/10/26 where is this page? Had directed that. No, had directed had forfeited. No, had allowed forfeiture of rupees 5,79,376, which was available in the Mizoram Rural Bank Aizawl branch account number SB 4813, standing in the name of the respondent. Next paragraph. This court, the learned single judge, on considering the submissions made by the parties, had held that in view of Section 10, bracket 1 of the 1952 Act, an amount standing, had held that the amount of rupees 5,79,376 being the Provident Fund amount payable to the petitioner, respondent, was protected It also held that Section 60, bracket 1, bracket K, CPC made a clarification with regard to the protection of the provident fund of a member in the fund provided in the 1952 Act. The learned single judge held that when no amount standing to the credit of any member in the fund could be attached under any decree or order of any could not be attached, the forfeiture of the respondent's provident fund, which had been transferred from the fund defined in the 1952 Act to the SB account of the petitioner and respondent, could not be forfeited. Full stop. it does, no, the learned single judge just directed refund of the forfeited amount of rupees 5,79,376 to the respondent. Next. The learned counsel for the appellant submits that the protection provided to the provident fund of any member under the 1952 Act would only be in terms of that particular member's money lying in the fund as defined in section 2 bracket H of the 1952 Act. Full stop. He submits that once the provident fund of the respondent had left the fund provided in section 2H of the 1952 Act and had been deposited and had been credited into the SB account of the respondent, section 10 was no longer applicable. The protection afforded by section 10 was no longer present. Full stop. That's all, I think.
Yes,
that's all.
some substance.
Next, Mr. C. Laramzawa, the learned senior counsel for the respondent, submits. What was the submission basically?
The interpretation made by the learned single judge is proper, right, and in accordance with law.
Okay. Submits that the interpretation given by the learned single judge with regard to the immunity provided to the provident fund of the respondent in terms of the 1952 Act from attachment was correct, and the same, and the said decision, and the said impugned decision should not be interfered with. We have heard the learned counsels for the parties. Section 10, Section 2 bracket H, and Section 2 bracket H bracket L and 10 of the 1952 Act and 10.1, you said 10.1, 10.1 of the 1952 Act states as follows.
If I may, Lordship, J also defines member.
J also. So you make it H, J, G, H, I, J, you make it H, J, and L, okay? And 10 bracket 1 of the 1952 Act states as follows. Full stop. A perusal of the above provisions of the 1952 Act clearly shows that the protection against attachment provided to the provident fund of any member would only be in relation to the money that has been put in the fund established under a scheme in terms of the 1952 Act. It does not provide for any protection of any money, provident fund or otherwise, comma, if the same by the member. In the present case, there is no order passed by any court for attachment. There is no decree or order passed by any court for attachment of the provident fund of the respondent. Full stop. In view of the above, in view of the above, in view of our above interpretation to section 10, read with section 2, H, J, and L, we do not agree with the findings of the learned single judge in directing a refund of the forfeited amount. The impugned judgment and order passed by the learned single judge has clearly stated in para 9 that the amount, the provident fund amount was credited in the account of the petitioner's late husband, in the account of the respondent's late husband, by check number 891112, 891112, amounting to rupees 5,79,376. Which is exactly the amount which has been forfeited from the account of the respondent's late husband by the impugned order dated 9/10/2006. The above fact having clearly proved that the protection given to a provident fund of a member, having left the safety, having left the protection provided under section 10(1) of the 1952 Act, there was no infirmity in the forfeiture of the amount from the account of, from the savings bank account of the respondent. The above being said, the one other aspect of the matter is that when it is proved beyond all reasonable doubt that there has been embezzlement / misappropriation of money and which has attained finality as on date, there is no reason not to realize the embezzled amount from the property of the said individual. Full stop. Next paragraph. One other aspect of the matter that bothers us is the fact that the departmental inquiry culminated with the finding, with the dismissal order in the year 2005, and the criminal case ended with conviction in the year 2009. The writ petition was filed by the respondent claiming refund of the forfeited amount in the year 2023. And the only reason given for the delay in filing the appeal is reflected in para 11 of the writ petition, which states as follows, page 49. I'm giving this, hey. Para 11. A perusal of the same shows that no reason has been provided. No proper reasons has been provided for the huge delay. In filing the writ petition. We are of the view that, however, in view of the fact that we find no infirmity with the action of the appellants in forfeiting the indirective forfeiture of part of the embezzled amount, embezzled/misappropriate amount from the savings bank account of the respondent's husband. Respondent's husband, no? When did he die?
2016.
Respondent. Achha, you have to write somewhere. Huh? The respondent's husband died in the year 2016. Or respondent died. I'll correct that. We do not wish to make any observations except to say that ordinarily proper reasons should be given for entertaining a writ petition after a lapse of many years, which has not been done in the present case. For all the reasons stated above, we are of the view that the appeal should be allowed. The appeal is accordingly allowed. Consequently, the impugned order dated 18/10/2024, passed in WPC 116 of 2023, is hereby set aside.
Obliged.
Item 13.
The writ petition is accordingly dismissed. No, we have time. Yes.
Lordship, this is a criminal appeal, and this is the NDPS. The appellant was convicted under Section 22C of the NDPS Act.
You are for the customs or not?
No, Lordship.
You have left? Who is for the customs now?
No, this is not a customs case. It's a state against the state.
Okay. So you are having both the bread and the butter. 22C and 29.
Lordship, yes.
So what is wrong?
Lordship, there are so many discrepancies, Lordship, and the first one is the two civilian witnesses, PW number 2 and 3, stated that while taking oath and during the recording of the statement before the court and taking the oath, the trial judge was not present.
Trial judge was not present.
Lordship, yes. This is the one of my case.
Is it proved?
Lordship, yes.
Or are you saying it just out of hand?
That has been
you
clearly
have
stated.
got to prove it.
Lordship, that has been clearly stated in the cross-examination of the PW number 2 and 3. So the evidence adduced were not reliable, Lordship, and it cannot be considered as a reliable truth.
How? No, you have to prove that.
Lordship, yes. And the second one is the PW number 4.
So is it a requirement that for taking oath, the magistrate has to be there.
Lordship, without the presence
Did
of
you
the
take,
magistrate...
did you take oath?
Never,
No,
Your
you see
Lordship,
that-
never, Your Lordship.
You took oath or not? No, did
Oath-
you take oath whether in the absence of the
In the absence of
magistrate you
trial
took oath?
magistrate.
Correct.
Lordship, yes.
So you took oath. Was the evidence given during the absence of the magistrate?
Also, that was recorded in the absence of the magistrate.
No, Mr.
Oath
Mr.
was
Counsel,
taken in the
it's like
absence
this,
of the
it's like this.
magistrate cannot be.
Mr. Counsel, there's one
Lordship,
thing.
yes.
What prejudice is caused to you if while taking oath the magistrate is not there?
Lordship, that is one of my grounds. And my
No, but you have to tell us. If you say a ground, and if you want to say that this is one of the reasons that they should be acquitted, you have got to show us what prejudice has been caused to you.
Lordship, as per my understanding, the oath should be administered in the presence of the magistrate.
Where?
And the
Where does it
evidence
say
should
that?
be, Lordship.
Where does it say that? Show us the law.
Lordship, that my understanding and my interpretation.
Your understanding may be perfect. Problem is, our understanding is not to your level. So you have got to teach us. Where is it? We also want to learn. You all might be knowing more in some aspects. We might be knowing more in some aspects. It's a two-way traffic. So that's why we're asking you these questions. I don't know. Whether you want to ask anything?
Before oath. During the position and cross-examination was present. Before oath.
So how does that prejudicial if he has taken it?
And Lordship, that my second ground is the PW number 4, prosecution witness number 4. He stated that his statement were not correctly recorded by the police personnel. That has been clearly stated before the court.
What?
That has been clearly stated by the
His
PW
statement
number
has
4.
not been recorded by the police personnel.
Lordship, yes, that has not been recorded correctly by the police personnel.
How does it matter?
Lordship,
Is
that,
it-
because there are so many
No, you
discrepancies,
see,
Lordship.
Police admission and a statement given to a police is inadmissible in evidence in any event. That is why section 25 and 26 are there. Then how does it prejudice you? It is inadmissible in any event. It's not taken to be admissible as in evidence.
And Lordship, the another aspect is that there is no sample were not drawn at the spot, Your Lordship. This is a clear violation of the Standing Order 1 of 1989, Your Lordship. Samples should be drawn at the spot.
And what does section 52A say?
Section 52A is also in the consonance with the this standing
What
order.
are the judgments of the Supreme Court, Mohanlal? What does it say?
Lordship, that Mohanlal came later on. This has been in the 2019.
But you see one thing, a judgment, why is it not applicable to your case?
Lordship,
A judgment is always retrospective in nature.
No, Lordship, that it should not be retrospective unless specifically
Why
mentioned
not?
that.
Why not? Why not?
Lordship, the Supreme Court had clearly
Supposing MACT case happens, supposing accident happens in the year 2000, the judgment is given 10 years later. Will a judgment that is pronounced by the Supreme Court after the accident not be applicable to the case in hand?
Lordship, here in the 2013 2 SCC 212, here it clearly says that in the criminal jurisprudence, that it is a settled principle of interpretation of criminal jurisprudence that the provision has to be strictly construed and cannot be given a retrospective effect unless
You see, Mr.
legislative
Counsel,
intent.
you don't make a mistake between a provision of law and a judgment. A provision, say POXO Act.
Yes.
POXO Act, earlier the minimum sentence was 10 years under section 6. In 2019 it became 20 years. So any offense that occurred prior to 2019 that the old provision would be applicable. That is a statute. We're talking about a judgment on a question of law, not on the provisions of law as per se. Don't confuse the two. Otherwise, what will happen? Like I said, MACT case of say 2010, and then Pranay Sethi's judgment comes in 2000 when 19, 17, 18, whatever. Will not, and the judgment is pronounced say in 2020. Can't they apply Pranay Sethi's judgment or Sadhana Lord's judgment? Or, all those. So, Pranay Sethi's judgment is also used backwards. It does not mean that judgment can be applied only from the date of its pronouncement. It has to apply to the facts prior to that.
And Lordship, another grounds which, if Lordship...
No, you see, we are questioning you because we want to understand also. We are not saying that we are right.
Yes.
Next.
Next, my next ground is that the prosecution had stated that the SA was recovered based on the confessional statement made by the appellant, Your Lordship. Appellant, Your Lordship. But however, the FIR and the report of the seizure and the arrest clearly indicates that the seizure were recovered prior to the this statement, prior to the apprehended of the appellant, Your Lordship. And that has been clearly stated in the FIR, which is at page 1, Your Lordship.
It will take very long. How much time will you take?
It will take time, Your Lordship, because
I don't think we have got that much time. We've got single bench also. I think for today, tomorrow I've got some fixed hearing also.
Day after.
I don't know, we can try. No promises, because otherwise, what happens is at the end of the week, we've got tons of things to write. We've got to apply our mind, because otherwise any mistake you all will catch on. We've got to be careful. So we'll, list it for tomorrow. How long will you take?
Lordship, it may take time, because if Your Lordship permits me, I have to read. It may be.
We want to approximate.
45
minutes.
And you, madam?
No, that's so long, Your Lordship. It will take around 45 minutes also.
1.5 hours.
So 1 hour.
And what about us? We have got to take time also. Can you give us a point form?
Lordship, yes.
Point form.
Lordship, yes.
Your grounds of challenge.
Lordship.
Grounds of challenge, eyewitness, disclosure, statement,
Lordship, yes.
and the judgments that you rely upon on this point.
Right.
Just make that. Becomes easier for us.
Yes.
Other things we can look also together.
Okay.
But there is a judgment of the Supreme Court recent. It's not so strict with the provisions now, mandatory provisions.
I have some other citation also. I'll try.
Okay, right. List the matter. When? Day after?
Yes, Your Lordship.
Day after tomorrow. I forgot about our single bench. Yes.
Lordship, this is the case of where
For omission, item 1.
this is between the Serkan to Bakarot. Award was passed 3 of 2014. So after award was approved by the government, the state government trying to cancel, but alleging that it's a lapse. However, this Honorable Court saying that pay award in accordance with award already passed. And after that, the state government, they have filed appeal against the judgment order of the single bench, and wherein the court says that it's not set aside, the single bench order. In the meantime, while the appeal was pending, one case was filed, that is 167 of 2018, wherein the court is directed that you have to check the faulty process, however, pay the genuine owner within 2 months. So, however, the government, after passing that order, they have assessment, they made fresh assessment, all the claimants.
So, okay.
That is the case.
So you are there in the fresh assessment?
Yes.
Maybe-
I'm there. They deducted, we are genuine landowners, saying that some are bogus claim. But we are genuine owner. They have, my award is about 40 lakhs. However, in the fresh, they paid me 20 only. That
So
is
you
the
have
case.
been given 20?
Yeah, I have on protest with the permission of this court.
So
on
another
protest.
20 is to be given if
Yeah.
you win the case.
Yeah, if
So now you are challenging the new assessment.
yes.
What has happened to the appeal?
Appeal, it says that
Is it still pending or is it disposed
no,
of?
it's disposed. However, it's not set aside, saying that 167 of 2000, in accordance with 167 of 2018, judgment is there. And in accordance with, they have paid award, reassess award.
No, so the one.
Yeah, Your Lordship, I'll give you the judgment order here.
Yes.
Your Lordship, at this stage, I would like to submit before the court that there is actually a list of appeals which have been filed challenging the common judgment and order regarding the Saikan Bagai case, and the LA appeals have been listed as LA appeal number 4 to 18 in 2025, and they're also pending before the High Court, Your Lordship.
Where?
Not that.
In this,
Your Lordship is disposed in this case.
That is, Your Lordship, it is disposed.
Different case.
It is a different matter, however, Your Lordship, they all emerged from the same judgment and order.
No.
Which judgment and order?
Of the, Your Lordship.
No, the mix-up, Your Lordship, the thing is that the award number 3 of 2014 is not set aside by any court.
You mean the earlier award?
Earlier award.
No, but then the government has
On
superseded
that award, they just reassess, and they, they delete some bogus claim. We are in genuine owner, they just deduct my award.
They just lowered your compensation amount.
Yes, that is there.
The area remains the same.
Yes.
Your Lordship, if...
So the issue is this.
Yes, Your Lordship.
If the petitioner is a genuine owner,
Yes, Your Lordship.
and it is accepted by you as a genuine owner, the area is accepted as the same.
Yes, Your Lordship.
What was the reason for lessening the compensation amount? That's the only issue.
Yes, Your Lordship. Your Lordship, if I may, the submissions were made back in 2022, and this case was kept dormant because of the appeal before the principal bench. And so, Your Lordship, in that regard, if I have sought instructions as to whether there's any new development in this case from the concerned
So what
PWD.
did the appeal? What did the appellate court say?
Your Lordship.
How was it disposed of? This one? This is the one?
Yeah, that is the one. It says that, Your Lordship, kindly see para 14.
No, what was the decision made in 167?
167, the decision is that the direction is that the Lordship, it says that, I have the copy also, Your Lordship, here.
Madam, only one problem, there's hardly any time.
Yeah, I know. That's right.
There's no time to really go through this now.
Yes.
I've got some meeting also lined up.
Let's see tomorrow, Your Lordship, if possible, if time permits.
Mm-hmm.
167 direction is that Your Lordship para 8. Identification of the actual affected person and subsequent disbursal of compensation to the affected person within the period of 2 months. So its direction is not to make reassessment.
That's what.
Yeah, that is the case.
So the only issue is, if in terms of this order, 167,
Yes,
you are found to be genuine,
yes.
then you should be paid the compensation
Yeah,
amount.
according to the...
Then why is this appeal? Filed by whom? Acha,
Filed by the state. Against that...
against this...
against, not that. Against WPC 10 of 2016.
Now, what is WPC 10?
10 is, Your Lordship, award. Award was passed by the government. After that, they are trying to cancel.
The same plot of land.
Same plot of, same award. So, some of the claimants approached this Honorable Court. This Honorable Court says that they cannot cancel. So, pay according to the award. That's the case.
I think we have no time, I think.
Yes.
Because I think to really, for passing an order, I'll have to hear you all properly.
I know. If the time permit tomorrow, if not, it's okay. That's
Very difficult. Tomorrow we have some fixed item. Difficult, madam, difficult. Though I understand your case now.
Yes.
Only thing is that I have got to know all the facts. That means all the judgments I have got to read. But a basic case is that award made 40 lakhs, challenge made to the cancellation allowed, then assessment made, and in the assessment you are found to be genuine, but your compensation has been reduced to 20
Yes.
without any reason for the same.
Without any reason.
That's all. That's a case. That's a case. That's a simple case in a way.
Yes, Sir.
Now, why was the only issue you will have to address is why was the value reduced, value of compensation? On what ground? That's all. Right, due to paucity of time, I'll list the matter. I don't know tomorrow if we have time to do. Let us see day after tomorrow. We have fixed the other one day after tomorrow also. Day after tomorrow. Let's see if we have time. No promises.
Yes. Okay.
Because tomorrow I've got some fixed hearing matters.
Item 2.
Yes. You want time?
Yes, Your Lordship.
Who are you?
I'm petitioner.
What you want time for what? We are for respondent number 4.
No, my lord, I'm hearing for my senior on behalf of respondent number 5, the Tourism Department, my lord.
Are you filing anything?
My lord, as per the last order, we were to file our affidavit in opposition, my lord. However, since there was some miscommunication in our end, my lord, we're not able to file it. So if we
Who is
may
respondent number 4? Respondent number 4 was given time.
Yes, Your Lordship.
Have you filed?
Yes, we have already filed our affidavit in opposition, and additional affidavit.
Respondent number 4 has not filed. That's what the office note says.
So
When did you file?
Your Worship, respondent number 4 is Kala.
Who is appearing for Kala? That's why you have not filed.
Your Worship, we have filed the additional affidavit on 4/7/2025.
Mr. Counsel, there is a. Oh, is this a mistake? What? J.C. Lanusanga.
Yes, my lord.
You have got to file.
Yes, my lord. We're appearing on behalf of the tourism
5.
department. Yes, my lord.
Oh, okay. Tourism department is also getting compensation.
Yes, my lord.
How?
It
You're a
was to
government.
be apportioned, my lord, between the petitioner and the tourism department.
Why should you get any amount? Anyway, right. Miss
Daphne Lashotlongi.
Daphne Lalfroitloangi appearing for respondent number 5.
Yes, my lord. On behalf of my senior Jessie Lanusanga.
Appearing on behalf of Mr. J.C. Lanusanga, submits that she will file affidavit in a position within
A week, my lord.
a week. Are you sure? Within a week. Mr. A week? Are you sure a week?
2 weeks, my lord.
2 weeks. Mr. Have you filed? You have filed already?
Yes, we have already filed.
You have for respondent number 4.
Yes, on
Mr.
behalf of Mrs. Mary L. Kiangte, Daniel Russell.
Mr. Daniel Russell appearing on behalf of Ms.
Mary L. Kiangte.
L. Kiangte.
Yes, Your Lordship.
Counsel for the respondent number 4 submits that affidavit in a position has been filed on
Affidavit in opposition is being filed on 25/25 and
25/25 and
additional affidavit has been filed on 4/7/25.
an additional affidavit filed on 4/7/25. You are appearing for whom?
I'm appearing for respondent number 1 and 2 on behalf of my senior.
Who is the senior?
Zaudin Puyat Namte.
Who?
Zaudin Puyat Namte.
Are you filing any affidavit?
Yes, we have already filed.
You have already filed. Mr.
Samuel Mal Sondong Zela.
Samuel Mal Sondong Zela appearing for the respondent number 1 and 2 submits that affidavit has been filed for the respondents number 1 and 2. Correct?
Yes.
You, madam?
Lordship, I'm appearing on behalf of respondent number 3 for my senior central government council.
Have you filed?
No, my lord, we will not be filing.
Okay. Miss
Baby Laldin Zwali.
Baby Laldin Zwali appearing for the CGC.
Yes, my lord.
CGSC or CGC? CGC submits that. CGC counsel for the respondent number 3 submits that they will not be filing any affidavit. This is the matter after 2 weeks.
Much obliged.
Item 3.
My lord, I'm appearing on behalf of my senior, Mr. Elias Shima. So, my lord, we will not be filing any affidavit reply.
Then who else is there?
The matter may come up next week, Your Worship, then. For admission hearing. 27.
Right, Miss Ruth.
Lalwat Feli.
Huh?
Lalwat Feli.
Lalwat Feli is appearing for the respondent number?
1 to 3, all the respondents.
1 to 3 submits that they will not be filing any affidavit.
Any further affidavit?
Any further affidavit. List the matter after a week.
In the next week.
I'll list the matter in the next week.
Item 4.
May it please your Lordship. Lordship, this writ petition raises an issue. It may be very narrow, but Lordship, there is a very serious constitutional issue concerning the long-term unauthorized utilization of the petitioner, who is a Group D employee on a higher post, Lordship, without any pay, without any authority of law and status, Lordship.
Huh?
Without any pay, without any authority of law.
You're not getting any pay?
No, without any pay parity, Lordship. That's what I meant.
What do you mean pay parity? You're working as what? You're
As a Group D employee, Lordship, yes.
Then you have been sometimes been asked to be a driver.
Not sometimes,
So
Lordship.
you want to be a driver. Well, you're not a driver.
No, Lordship, definitely that's true, Lordship. We are definitely not a driver, Lordship. We are a Group D employee, Lordship. But as per the office certification, Lordship, it has been stated.
Were you recruited after the advertisement?
No, Lordship, we have not been. No, Lordship.
When did you start working?
We have been employed since 14 November 2007, Lordship.
2007.
Yes, Lordship.
As a Group D employee.
As a Group D employee, Lordship.
So what do you want now? You want the pay of a driver?
Lordship, if it may be possible, Lordship, what our only prayer here is that, Lordship, if our 17 years of continuous service can be considered, Lordship.
That is a different prayer. Let us see your prayer. Let us see your prayer.
Page number 19, Lordship.
Your prayer. Please read your prayer.
Lordship, in the premises aforesaid, it is therefore prayed that your Lordships may be graciously be pleased to admit this writ petition, call for records, and issue rule calling upon the respondents and to show cause as to why the writ petition should not be allowed as prayed for. After hearing the parties, be pleased to make rule absolute and direct the respondents to hold departmental promotion committee to consider the case of the petitioner for great promotion by taking his appointment, which has been utilized as driver since the date of his initial appointment, and to pass any such orders.
You see, Mr. Counsel, first of all, you are praying for promotion.
Yes, Lordship.
You are not even a regular employee.
True, Lordship. That is the reason why, Lordship, we are...
So, you see, you are building your house. Say you are employed as a contract employee or MR or whatever. You are what? MR?
Lordship, yes.
You are MR. So, let us consider that the foundation of a house.
Yes, sir.
Now, for promotion, you have to be first a regular employee. So, regular employee will be ground floor and then promotion will be first floor. Now, you are not even asking for regularization. You have to be first regularized. Then you can pray for promotion.
Lordship, we have been confirmed into the service, Lordship. We have the confirmation order.
Okay, you have been confirmed.
Yes, Lordship.
Where?
Annexure 9, Lordship.
Page?
If I may give. Page number 32, Lordship. Annexure. Lordship, Annexure 9, page number 31, Lordship.
Page number 31.
Yes. No, sorry, my mistake, Lordship. Page number 32, Lordship. Annexure 10.
Okay. Okay. So?
Annexure 10, page
now
number...
you want promotion.
Lordship, if we may be considered our years of service, Lordship, if it may be considered...
So show us the rules. You see.
Lordship...
now you see, for promotion, you want promotion to which grade, to which post? What is your promotional avenue? You have to show us that.
Lordship, the statutory rules is governing our recruitment is given in here, which is the Group D recruitment rules, Lordship.
Page?
Page number 35, Annexure 11.
Page 100 and?
Page number 35, Annexure
35, yes.
Annexure 11.
Annexure 11, yes.
So, if I may, sorry, page number 36, if I may go to number 7, Lordship.
Yes.
If I may go to power to transfer. Nothing and notwithstanding anything contained in these rules, the Governor of Mizoram in public interest shall have the right and power to transfer any officers so recruited under these rules to any other post or position which is equivalent in rank or grade. So, Lordship, here our situation is that we are from Group D, Lordship. But there is, these rules permits horizontal transfer, Lordship. But
transfer to what? Transfer to another?
Another cadre, Lordship, another cross cadre.
So have you prayed for that?
Lordship, we have not prayed as...
Then how, you see, if you are going to pray for transfer to another cadre, you pray for it. You have to first make a prayer, then you come to the court. But then you have got to show us. Is your post equivalent to a driver's post? You want to be a driver,
So,
basically.
Lordship, what this rules, as my humble understanding, is that it does not allow any cost cadre, transfer, Lordship. It allows only horizontal transfer, which we are under Group D, Lordship.
Correct.
Whereas the driver is under Group C, Grade 3, Lordship. So, Lordship,
How can you ask us to do an illegal act?
So, Lordship, we are not asking this honourable court to create any.
Then if you want the government to apply Rule 7, why don't you ask the government? Why are you asking us?
Lordship, why we are asking this honourable court is because, Lordship, there has been a constitutional, constitutional illegality in the utilization of his service, Lordship.
You mean to say there's an illegality? It is not a constitutional. It's an illegality, basically.
Yes, Lordship.
So, what is the stand of the government in that aspect? What have they said? What have they said? Is it your case that you are being used as a driver every day?
Lordship, for the past 17 years, Lordship.
For the past 17 years. Come to page 3, para 4.3 of the affidavit in opposition. Please read 4.3.
4.3, Lordship.
Yes.
Okay. The petitioner's claim of performing duties is misleading. While it's acknowledged the petitioner was assigned incidental tasks involving driving a vehicle on certain occasions due to administrative needs and the temporary absence of a regular driver or other logistical reasons, these assignments were temporary and did not change the substantive posts or duties which the petitioners are.
So this is a question of fact which has been disputed by the government.
Yes, Lord.
Now am I going to decide whether what you say is correct, that you are being utilized every day, or should I decide that they are correct? How do I justify, or how do I accept the statement of one person over the other?
Lordship, if I may kindly take your Lordship to page number 45, Lordship.
45.
Annexure number 14, Lordship.
45.
45, Lordship.
Yes.
Yes, so this certificate has been, this letter has been issued by the same department, Lordship, which is employed under. So, Lordship, if I may go through this.
Now, you see, the problem is, I agree, I understand what you're saying. The problem is, this is a certificate issued, which has to be proved by evidence, for the simple reason that this affidavit is on oath.
Yes.
This certificate is not on oath. This certificate has not been issued by you. This has been issued by Dr. Vanlal Verna. He will have to prove the contents of this. When there is dispute with regard to facts, then we will have to take evidence. Now they are saying that no, you are being used temporarily. You are saying that you have been used permanently, and you have given this.
Yes, Lordship.
Now, how does this court decide whether you are correct or she is correct? Whether we take it by beauty, she is more good looking than you, or you are more taller than her, or what?
Certainly, Lordship, that may be a very important question to prove before this honourable court. But, Lordship, the situation in
anyway, the fact is this.
Yes.
You have been taken in as a Group D employee.
Yes, Lordship.
According to you, you have been used as a Group C employee. Now you want to be promoted to a Group C employee by using clause 7 of the rule 7 of the rules.
Yes, Lordship.
Transfer. Now, first of all, this court cannot do it because that power is given as per the rules to the authorities, not to the court. Secondly, the question of whether you have been employed as a driver on an everyday basis has been disputed by them. So, we cannot decide. You have to decide. There is no case otherwise. I don't find any case.
So, Lordship, if this honorable court does not interfere in this, Lordship, is that, Lordship, there will be other situations where the petitioners are, are actually and factually employed.
So
Lordship.
you see, first of all, you have been employed, you have been appointed as a driver.
Yes, Lordship.
You have not been appointed, you have been appointed as a Group D.
Yes, Lordship.
You have to be given Group D work. You cannot, we can say that since he's given Group D, he should be given Group D work. Just because you have been asked to perform a Group C work, does not mean you have got any right to be a Group C personnel. Group C, if they require, they will have to issue advertisement or, follow the procedure. Because a lot of people want to apply also. You cannot take the back door just because you have been employed, because they might have been utilizing your service. There's no case.
So, Lordship, the petitioner is not seeking for any great promotion for this, Lordship, per se, but Lordship, the action of the state respondents clearly.
Okay, we'll clarify that since you are a Group D, use him only for Group D. That's all. What can we do?
Lordship, it may be, but it may be done, Lordship, prospectively, Lordship, but it cannot absolve all these 17 years of service, Lordship, of the petitioner.
No, but that is a question of fact. They're disputing it. They're saying that occasionally you are used. So you clarify on which date you have been employed as a driver.
Certainly, Lordship. Lordship, if
So
I may
these are
give-
questions of fact. No case, Mr. Counsel. No case. There's no point. There's no point. You see, this court is a court of law, not a court on facts. And your fact is crystal clear. You are appointed as a Group D employee. So you have to be, we'll give a direction to the authorities. He is a Group D employee, use him only for Group D services. That's all. You cannot claim something you are not. You're not appointed as a Group C employee. You might have been used for a Group C employee work, but you're not.
Lordship, at the very least, can we at least pray for the constitution of DBC, Lordship? So
How? What is your right? What is your right? You can ask for promotion if you are entitled to promotion from Group D to Group C. But show us the law. Show us your post, your next promotional post, and show us that your post is a feeder post to the promotional post. Show that. That doesn't mean that we can just pass, hey, bring me chow or something. It's not that. We have got to go by the law at least, as far as possible. We cannot order things that we feel is, should be done or not. There has to be a basis. Yes, madam.
Yes, Your Lordship. I would just, in addition to the affidavit opposition submitted by the state, I would just like to state that this particular petition actually attracts delay in latches as well, and also regarding blowing hot and cold, because once he had actually accepted and engaged as a contractor at that stage, even if he was engaged.
Now he's regularized.
Yes, Your Lordship, but at the same time, Your Lordship, it attracts the question of delay in latches and also regarding blowing hot and cold, because Your Lordship, at the time of him not being used as a Group D and he being used as a Group C, he should have actually raised the question that's at that particular time, instead of coming after 17 years.
No, that is not the question. The question is basically, is
And
a Group
also,
D,
Your
you
Lordship-
employ him as a Group D. You see, you've got to look at the practical side of things also at times. At times, they might ask someone, hey, my driver is not here. Just, since you know how to drive, just drive for 1 day, 2 days. That's what they're saying basically in their affidavit. You, on the other hand, are saying that you have been employed for years to come. It might be correct. But this court cannot go by what you say only. Well, this is a disputed question of fact. And you are employed you are appointed as a Group D. That's the thing. So either I do not know what we are going to pray for. Otherwise, I am going to dispose of the matter. This is clear cut. We can't allow this type of petitions.
Lordship, you might be then given liberty to withdraw the case, Lordship.
Yes, maybe, but you think of how to approach. You cannot, I don't think you will succeed by saying that, I am Group D, but since I have been driving a car, I should be made Group C. That cannot be done.
Lordship,
you have,
just make a small mention, Lordship, although there are some work orders which are given to the petitioners, Lordship, which we do not unfortunately annex in this particular documents, Lordship. There are quite a few, but among the others, Lordship, most of have been either lost by the petitioner or either is still in the department.
work orders for what?
From the department for being engaged to work on separate occasions, Lordship. More than one occasions, Lordship.
Maybe, but that amounts to what? That amounts to utilizing your services beyond your work, beyond what you're supposed to do. But that does not give you a right to jump over the others. Only thing you can say as per law is that, look, I am a Group D. If you want a driver, start a recruitment process. Is the post of Group D, Group C, the driver post, is there any vacancy?
Lordship, there are vacancies at the moment.
So have you asked, how is the post of drivers to be filled up as per the rules? Is it promotion or is it as per direct recruitment?
Lordship, there are mostly all direct recruitment, Lordship.
No, you have to see the rules. It's not mostly. The rules will say whether it has to be filled up by way of promotion or direct recruitment. Okay? If it is by way of direct recruitment, there is no question of having a DPC.
Lordship is given in page number 42, Lordship.
What does it say?
Lordship, driver grade 3, non-functional, Lordship. Education qualifications are, Lordship, if my passed in class 8 or above, recognized institution, possessing professional driving license either in heavy or medium or light motor vehicles. Candidate shall pass examination conducted by the motor vehicles inspector in number 1, driving, signal test, road sign, practical knowledge of the components mechanism of all type of vehicles, working knowledge of standard and at least middle school standard. Now, Lordship, now regarding the post, Lordship, is given in column number 12, Lordship, of page number 42. And the method of recruitment, whether direct or recruitment or by promotion or by deputation absorption, and percentage of the sanctioned post to be filled by various methods. These are mostly all promotions, Lordship. And promotion now,
Mr. Counsel, you see, they are driver grade 1, driver grade 2, driver grade 3. Okay? You cannot become directly driver grade 1. You have to start from driver grade 3.
Lordship.
Yes.
That is what I'm mentioning right now, Lordship.
It is 100% direct recruitment. Page 43. You'll be driver grade 3, then you'll be promoted to driver grade 2, then to driver grade 1. So you cannot be promoted to the post of driver grade 3 when it's a recruitment post, direct recruitment post. Now, what is your prayer? Your prayer is for promotion to the post of driver. Now, which post of driver do you want to be? Grade 1 or grade 2 or grade 3? Grade 1 provides that promotion is from grade 1, grade 2.
Grade 3, Lord.
Then grade 2 promotion is from grade 3 and grade 3 is by direct recruitment. So it cannot be done. So you have to see whether there is a driver grade 3 vacancy available. Then you have to ask the government to follow the process for appointment. You can tell them, please fill up the post, make a recruitment process, and then if they feel that you are eligible, they'll promote you. Otherwise, you will have to go for promotion in your own line. If there is a promotional avenue, I don't know. No, there should be. From grade 3 to grade 4 to grade 3, there must be some post.
Yes, Your Lordship, but then it'll also be dependent on the recruitment rules and also the
Yes,
qualifications.
naturally, and seniority and all, but it's there. It has to be. It will not be a end of the road kind of thing. But your writ petition does not survive, Mr. Counsel. You got it, no?
Yes, Lordship. So you may be given a liberty, Lordship, then.
Liberty to do what?
To withdraw the case, Lordship. If it's so required, then I'll, for liberty to file a fresh, Lordship.
Okay, Mr.
Samuel L. Patswao.
Learned counsel for the petitioner prays that he may be allowed to withdraw the writ petition with liberty to file a fresh. Praise allowed. Writ petition dismissed as withdrawn. With liberty as paid for. Acha, wait, you also write Ms. Nandun Dui appears for the state government.
Yes, Your Lordship.
For orders 5 and 6.
So we have to issue notice here. Or what? Acha, who is, yes, come next. Yes, any objection, madam?
No, my lord.
No. Okay, right.
My lord, in fact, the respondent number 2, ID card has not been returned. And we have disputed he is the owner of the accident vehicle. We have disputed the
You are for whom, madam?
insurance policy.
You are the claimant.
I'm the claimant.
You are the claimant and the respondent number 2 is the?
Owner of the accident vehicle.
Anyway, we'll issue notice again.
My lord.
Heard Mr. T. Lal Zakima, learned counsel for the applicant, who submits that there is a delay of 189 days in filing the appeal against the impugned judgment and order dated 27/9/2024 passed by the MACT Aizol in MACT case number 38 of 2020. No one appears for the respondent number 2. Full stop. Despite issuance of notice to the respondent number 2, there is no return of AD card or unserved notice from the respondent number 2. Full stop. In the order dated 28/11/2025 passed by this court, it has been stated that if service upon the respondent number 2 is not complete by the next date, the prayer for condonation of delay may be considered in his absence. Full stop. The respondent number 2 is the owner of the vehicle, accident vehicle.
My lord.
Full stop. Miss
Ruth Lalwat Ferry.
Ruth Lalwat Ferry, appearing for the respondent number 1, bracket claimant, submits that she has got no objection to the delay being condoned. Next para. On considering the grounds of delay provided in
from page number 3, my lord.
Para 2 to para 2 and 3 of the application, and keeping in view the submission made by the counsel for the respondent number 1, the delay of 189 days is condoned. I is accordingly disposed of. Next para. What is the ground for challenge?
My lord, one of the main grounds is that the accident vehicle was a taxi, and however, the insurance policy that was issued was for private car.
Okay.
It should have been commercial
Right.
vehicle package.
The heard Mr. Tila Zakima, learned counsel for the appellant. Also heard Ms. Ruth Lalwat Ferry for the respondent number 1. This appeal has been filed against the impugned judgment and order dated 27/9/2024 passed by the learned MACT Aizol in MACT case number 38 of 2020, by which compensation has been awarded to the claimant, amounting to rupees
44,88,360
44,88,360
with 7% interest.
with 7% interest. The ground of challenge, the main ground of challenge to the impugned judgment and order is that the insurance cover had been made only with respect to private car, while the accident vehicle was a taxi. That's all. Issue notice to the respondent number 2. Appellant to take steps for service of notice upon the respondent number 2 by speed post,
My lord.
along with publication in a newspaper.
My lord. My lord.
Where is located?
He is a resident of Kanan Veng in Tenzon.
Having circulation in Kanan Veng, in Tenzon, having wide circulation in Tenzon. Steps should be taken within 3 days.
My lord.
List the matter after 5 weeks, give or take. Acha, 2 newspapers, make it 2 newspapers. 2 newspapers.
26 February.
That's all?
My lord. Yes, sir.
Next time you do cases, your first time doing case? Not exactly. You've got to be more careful. You see, you've got to see, you are asking for promotion to driver, but the rules do not permit.